Someone make it make sense.
Probably a couple.
Hello, everybody. How are y'all doing tonight? So, hope everybody is doing well. We are here with the latest onslaught, if you will, of documents out of Ada County, Idaho for Bryan Kohberger. Shout out to Flash Fan. Hope you had a good class this morning. So we're getting a little touch of Spicy Santa, Prosecutor Santa in these filings, as you will see shortly. So the plan is we're going to get through as many of these as possible. Just to sort of touch on what we had covered before. The defense had filed 13 motions to suppress, and I've covered all of those. If you're new to this channel or to this case or anything like that, feel free to check out the playlist. I have a playlist for every case that I'm covering or have covered, and you can find the coverage of those motions to suppress there. But the reason I'm mentioning the number 13 is because with the state's objections, they have 9 objections that we will be able to cover, and then 5 of the objections are under seal. And then the exhibits attached to all of the objections are under seal. So, but we will still get a good idea of what they are contesting in the 9 objections where the objections themselves are not under seal. Yes, that's right. It is a lot. There's been a lot of court filings in this case and a lot of litigation. They are fighting tooth and nail. And there are myriad issues as came up in those motions to suppress. For me, as y'all know, if you've heard this before from my coverage, the trash is a big one. And we've talked a lot about that. But in the interim, since the last time we covered anything on this, waiting for the next court filings, I've done a lot more research, guys. And so we're going to go over that today too. I've got some case law, Pennsylvania case law that we're going to take a look at. And I also have the search warrant for Washington as well. And some other things. I had made like a little list. So the other thing too is someone who had been watching before had told me that Cy Ray, who was the defense's expert cell phone examiner and who was extremely qualified, one of the best experts I've seen, he testified at one of the hearings, and I was like, holy crap, like he's really, really, really qualified and very, very, very respected. And I think it was the first time he's ever been hired by a defense team. And he was going to be looking at the cell data, like the location data and whatnot. Anyway, someone had told me that Cy Ray had quit because of the fact that he didn't, I don't actually remember why he said, but he said that Cy Ray quit. Anyway, I looked into that. I couldn't find that anywhere. So if anyone knows where that can be found, let me know. But I could not find that. Everything that I saw when I was researching it, he's still working for the defense. So there's that. So that was another thing I wanted to mention. Let me see if I had something else here. Just looking at my notes. Well, I'll keep looking. I'll see if I know I've got it somewhere. Oh, yes, I see. Okay. Yeah. So one question that I still have that I don't have the answer to yet, and I don't know if the answer is out there because so much is sealed, but yes. So one thing we don't know of, to my knowledge, is what trash specifically was collected from the garbage. But we'll talk more about that when we circle back to the trash. We'll probably do like half of these motions, then do a trash break, if you will. And then, so you don't know much about this case. Well, I can fill you in, and for anyone who's new to it. So, in November of 2023, oh my God, 2022, November of 2022 in Moscow, Idaho. Let me pull this up. Actually, let me do this real quick because this will be a good way to do this. Let's do this. Okay, so this will give us a good way to do like a little introduction to the case or a refresh for anyone who needs it. So in November of 2022, okay, so there's Moscow, Idaho, okay? So Moscow, Idaho, college town, very small college town. As you can see, it's right there on the border of Washington State. And so it'll go to the next picture here in a second. And so notably in Pullman, Washington, again, right there near the border, Pullman, Washington is where Washington State University is. So Washington State University and Moscow or University of Idaho are like 10 minutes away from each other. You just cross over the border. That's the Latah County Courthouse. They're not there anymore. As we know, they moved to Ada County. So I'm going to skip past some of these pictures of the Latah County Courthouse. That's the Latah County Courthouse again. Okay, there's welcome to Moscow. That's another picture of Moscow, but we're going to get to the house here in a second. Okay, the house. So these 4 college students, so there were 6 people in that house. Okay, and this is really close to university. This is like a college area, right? There were 6 people in the house, but 4 of them were murdered by stabbings. College students. Okay, so that's Kaylee, Ethan, Xana, and oh my God, why am I blanking on? Oh my God, it's been so long since we've actually talked about. Oh my God, Maddie. Okay, Maddie and Kaylee. Which is funny because I'm used to thinking Kaylee now from Casey Anthony. Okay, so Kaylee and Maddie, and they were like BFFs, okay? And then Xana and Ethan were girlfriend and boyfriend. Ethan did not live there. He was staying the night. And so he was staying with Xana. So yeah, there was Judge. Yes, Judge is no longer the judge because they changed venue. But so Ethan was staying the night. So it was just a normal night, you know. So this is like before Thanksgiving. And what's really interesting is that the timing of this is really crazy, right? So what happened was at there's like a 16-minute window of where this could have happened, because what happened was Xana, so this was like 4 a.m., okay? And Xana was still awake. She was on her TikTok, okay? Ostensibly, the other roommates were asleep. Also notably, Kaylee had a dog with her, Bailey. And so another noteworthy thing is that Kaylee had actually moved out and was going to be like moving to Texas to go to graduate school, I believe. And so so she was just basically staying for that one night. So her stuff was moved out. So we can take that to mean that her bedroom was probably empty. So it would stand to reason that she was sleeping with Xana in her room because they were BFFs. Now, the dog, Bailey, we don't really know yet where the dog was. Was the dog still in Kaylee's room? Was the dog in Maddie's room? I have thoughts on all this, but that'll be a whole separate thing. I have a PowerPoint presentation. Anyway, so it's like 4 a.m., right? And so, but again, we do know that Xana was awake because her phone showed she was on TikTok. And she had ordered DoorDash, okay? And DoorDash, the DoorDash delivery was at, I have it all in my PowerPoint. It was like at 4:04 or something, but basically that marks the latest that whoever was there could have gotten in the house, because she would have answered the door to get the food, right? They would have left. And actually there's no way around it that whoever the suspect, right? We have someone arrested here, Bryan Kohberger, but the suspect would have passed the DoorDash driver. And if the suspect vehicle is in fact the person who did this, that would be the white Elantra attributed to Bryan Kohberger. What we've seen footage from the neighboring like ring cameras and surveillance cameras and whatnot, that this vehicle did a U-turn. So what it seems like happened is that this car pulled up and noticed that there was probably somebody delivering DoorDash, did a U-turn because it's the only way to get, like, this street is like a dead end or whatever, did a U-turn and waited for that DoorDash driver to leave, and then they would have passed each other. And then this is what looks like probably happened. Okay. And so, but here's the thing is that this person had at most 16 minutes to get in and out of that house. Because then that white Elantra is seen leaving again. 16 minutes is the generous estimate. So the PowerPoint presentation that I've made, I haven't presented it yet, is called Unraveling the 16 Minutes, because to our knowledge, there was one weapon used, one knife. Okay. And this is a 3-story house. Let me get to the next picture of the house. Just a second. So it's a 3-story house. It's a 3-story house. Again, there were 2 roommates who were left alive. What we do know is that Kaylee and Maddie were on the top floor. And again, it would stand to reason that Kaylee was in Maddie's room because she had moved out. And again, we don't really know if her dog was with both of them or if her dog was in Mike mute itself. That's weird. Okay. It's not the Chad Daybell judge. It is Judge Hippler. So here's the 3 floors. So basically, so the 3rd floor, you have Maddie and Kaylee. Now that room where you can see that balcony, that would have been Kaylee's room. And again, she had moved out. So the dog could have been in there, or the dog could have been with both of the girls, but it makes sense that Maddie, and we do know that they were found next to each other. Okay. We do know that. So and I don't think they actually have come out and said, because again, there's been a gag order on this, like from the get-go, right? But it seems like it was Kaylee was staying in Maddie's room because she had moved out, and we don't know which room Bailey was in, the dog. Now on the 2nd floor, that's like the main floor, and we're going to see some pictures of the interior as well. And on that main floor is where you have the kitchen, but you also have Xana and Ethan, and then also one of the eyewitnesses who was left alive, also there. And then I believe the last roommate was on the 1st floor, but we're going to take a look here. We'll get to the next picture in a second. So they are in Ada County, but it's not the same judge. So here's the kitchen. Now these sliding glass doors are important because it is kind of believed that this is how the suspect gained entry to the house. And the other thing to note too is you might think, well, wasn't everything locked? Well, there's no question. This was a college house, college neighborhood, college town with like little to no crime. And I have no doubt that they left this unlocked. In fact, they are, after the homicides, a lot of footage surfaced of previous times where law enforcement had visited the house due to like noise complaints. And there were times where actually I think it was Dana came to talk to law enforcement officers, and she was like, they were talking about people that were like partying at the house. She was like, I don't even know these people. So it's clear that, like, you know, being a party house, people could come and go, you know, that type of thing. I have no doubt that it was unlocked. That's not really a question in my mind. So because people will come and go and party late at night, whatnot, right? So it'll go to the next picture here in a sec. Okay, there's another shot of the sliding glass doors. And this is, I believe, a living room area on the 1st floor. Okay, there's a bedroom. So again, all of these rooms have like sliding glass doors and or balconies. I mean, it seems like a nice place, but I mean, it doesn't exist anymore. They tore it down. But it's just going to go through some more of these pictures. There's another bedroom. And this is the 3rd floor. There's a bathroom there. I believe this is the 3rd floor. Yeah, this is the 3rd floor. Because I noticed that there's this like that panel up on the ceiling, like for an attic or something. I don't know. I thought that was noteworthy. That's why I included the pictures, because we don't know. Not a serial killer. He has no criminal record. Bryan Kohberger has no criminal record. I'm not surprised there's misinformation. There's a lot of misinformation, I'm sure, surrounding this case, without a doubt. I'm not surprised someone told you that. No. So that's another thing that's wild about this, right? So Bryan Kohberger, if he did this, right, he's been charged, he's waiting trial. He had no criminal record. Now, what he did, he was from Pennsylvania, right? And he had studied at DeSales University, and he was studying criminal justice under Dr. Ramsland, which I'm sure a lot of you guys are familiar with. She's the one who was the expert on BTK, still is the expert on BTK. Okay, huge, criminal profiler, and he studied under her and took her classes and whatnot. Okay, and so he was a criminal justice major. So then after DeSales, there's a period of time where no one's really sure. It was kind of during COVID. He might have been taking classes virtually, but at some point he comes to University of Washington. Now, at University of Washington, he was doing like a graduate level degree, and he was given some sort of like assistantship, it seems like, where he was like, like a lecturer or something. And then at some point they kind of fired him from that. Anyway, but he had no criminal record. And so it's a big thing if you've done like literally nothing, and then to be able to kill 4 people in 16 minutes, not with a gun, right? With a knife. Okay. So that actually technically would put him in the category of a mass killer versus a serial killer, right? Because with a serial killer, you have to have killed, well, it depends on who you ask, right? Because the standard changes. Some people, it used to be 3 or more, now it's like 2 or more. But the key thing there is the cooling off period. So time in between. So, it could be like 6 months or a year or whatever, time in between, right? And usually there is going to be implied like some sort of a modus operandi, right? With a mass killer, it's killing, 2 or more people at once. At the same event. So technically, if you go with that standard, even Alex Murdaugh would fit into that, right? But definitely you've got 4 people killed in 16 minutes. Okay. So correct. Yep. So this is just going to go back through, I think, some of the same slides. What was this last picture? Let me see. Let me go back. That is the laundry room on the bottom floor. Right there. So what happened was, one of the roommates, okay, awoke because, now remember, here's the other thing. When the suspect, allegedly Bryan Kohberger, was in the house, right? Remember, Xana was awake and on TikTok and eating her food, probably, right? She was awake and on TikTok. And there's every reason to believe that the suspect would have known that and still came in. Okay. And one of the surviving roommates, was awoken, hearing at first the sounds. She thought someone was playing with the dog, Bailey, because it was upstairs. Okay. This is all going to matter. Right. And I'm sure, they're going to have to testify at the trial. So awoke to hearing that. Then she kind of heard some whimpering. And basically what happened was she heard there was a number of sequences where she heard things, and she kind of opened her door to look like poke her head out or something, but didn't see anything. Okay. For the first 2 times. And at one point she heard somebody say, "Let me help you." You don't know who that was. You don't know what that's about. That's what she heard. And finally, the last time she opened the door and looked out, she saw, according to her, somebody dressed like in all black, with like bushy, all she could see was the bushy eyebrows. That was the notable thing, was the bushy eyebrows. And that this person was leaving, let me pull up the documents here, was leaving the house ostensibly and through the sliding glass doors in the kitchen, which again would indicate probably leaving the same way he came, maybe, right? I'm just sharing this back to you guys here. And noteworthy, of course, this roommate was left unharmed. So I think it's very likely that he just didn't see her because the lights were off. We also know that if Bryan Kohberger is the person who did this, he had complaints of visual snow and things like that. But there's a lot that goes into this, right? And we're, again, a lot of the details of what I think maybe could have happened in the 16 minutes from listening to the experts and kind of putting those things together is in this PowerPoint presentation that I haven't presented yet, but unraveling 16 minutes as to how this whole thing happened. But yeah, so you're left with these 4 students. So then what happened was the next day, right, the roommates, sort of came upon this, right? Because so they went back to sleep, or one of the roommates, the one that had seen him, went back to sleep. Probably thought it was just someone there partying, right? Because that's normal. Went back to sleep. The next day, like, apparently discovered the bodies or something, right? And then the next part is kind of, there's a gap, right? It looks like what happened was one or both of them went into what was called a frozen shock phase, where they were just in shock. And when we know that 911 was called, they were called because they were told somebody was passed out and unconscious. And it turns out that that was one of the roommates. I think it was what they call DB, her initials. So they show up to expect to find somebody passed out unconscious or whatever. And then they find 4 murdered individuals, So, right. Great question from Flash Fan, asking all the good questions for anyone who's getting familiar with this case. So great question. That's a great question. So here's what they have. Here's what was presented against Bryan Kohberger. So what happened was they didn't have anything except they had the white Elantra, because it was the only car seen coming and going in that time period. And they have the surveillance from, the neighborhood, but also like there's a gas station leaving town on the way back to Pullman, Washington. Okay. So that's really all they had at first was that. Now, as far as the crime scene is concerned, there was nothing left behind, to our knowledge, except for a knife sheath. Okay. So initially they had the knife sheath, and they could identify that as belonging to a K-bar knife, which can be purchased on Amazon. That's going to be relevant even as we get into the documents tonight. So, but that didn't mean they didn't have, they of course were sending that for testing, but initially, right, they had the white Hyundai Elantra. So the first thing they had to do was try to find out whose car was this. They didn't have a license plate or anything, right? So, but because this is a small town, right, they had enlisted the help of University of Washington to also be on the lookout for Hyundai Elantra, and they had a car expert guy originally give a wide range of years, and then eventually they kind of narrow that down or whatever. And I'm summarizing this, right? There's a lot more going into it. This is the summary. So eventually what happened was somebody at University of Washington said, hey, we've got a student here who's in the graduate program who has a car that matches this, and we have his license on file because he's, he was, almost like an adjunct professor, right? When you're a graduate student and you're teaching, they have his license and they have his name and it has his address. Like we've identified. So in other words, we've identified somebody who owns this vehicle, and this vehicle matches. Wait, hold on. I'm getting us ahead of myself. Maybe they didn't have. No, they maybe didn't have his. I'm trying to think. They at least had his address for the apartment because it was considered graduate school housing. That's what it was. Because the real thing and they ended up using to connect to him was the IGG. So, but it all started with the car and then the University of Washington. Okay. So because it was holidays, right? Thanksgiving, everybody had left for break, including Bryan Kohberger, the suspect. Now he drove across the country with his dad and was pulled over several times on that cross-country trip. And that body cam is available on YouTube, on, Long Crime and whatever else. You can watch it. We haven't actually watched it on the channel yet. Maybe we will do that next time. He was pulled over, or if you guys want to do that tonight, we can do that tonight. It's not long, but he was pulled over twice. And it was kind of funny because it was like they didn't really have a good reason. I think they might have said he was speeding or something, but some people have speculated that was the FBI and they were trying to keep an eye on him. It's very funny. There's some funny things that happen in that footage. Anyway, gets to Pennsylvania where his parents live, right? So this case, there's 3 states involved, and there's also the FBI involved, because you've got Idaho, you've got Washington, and you've got Pennsylvania. Of course, each one has their own separate laws, rules for doing things, and all that we're going to get into. So then the FBI are involved, right? And then he's at his parents' house in Pennsylvania, and they live in this private gated community on a private road, and the FBI is out there staking out the neighborhood. Apparently Bryan Kohberger is going running and whatnot, but they see funny things. They see him like cleaning his car out. They see him and I guess he doesn't see them. They see him sorting through, putting his trash in the next door neighbor's trash can. That matters. We're going to get to it. And whatnot, right? So what happens is, and there's a lot of details that are missing here as it pertains to the laws with the trash. That's part of what I think is really important here. But what we do know is that the FBI, they collect something from there's some discrepancy over if it was the neighbor's trash bin or the Kohberger residence trash bin, although I think it's more likely than not it was the Kohberger's trash bin. Now, remember, if Bryan was putting his trash in the neighbor's trash bin, they can't go through that trash bin. Okay. Well, it's questionable if they could go through any of the trash bins, but it does matter because some of the roads in this neighborhood are private and some are public. And this is all where it gets complicated with the trash. Basically, they pull an item out of the trash from what is believed to be the Kohberger's trash bin, and they find the dad's DNA. And then through IgG, that's how the IgG from this trash this is the whole thing. That's how they connected to Bryan Kohberger, because it was the dad's DNA. And then through IgG, they're able to connect it to Bryan Kohberger. And that IgG is used as the basis for everything else, all of the search warrants, everything. That's how they're able to make all the search warrants for his phone and his apartment and all this stuff, everything. And so a lot of what came out in these motions to suppress goes to this fruit of the poisonous tree. Now, what his defense team has been kind of going off of is that IgG is kind of, there could be some issues there. A lot of the information about this they have under seal, but that it's sort of a relatively new thing. And for me, I see it more that the IgG came from the trash, and there's some issues with the trash because they did not have a warrant for the trash. And anyone who's like, well, trash is public, we've talked about that. This trash, I think, and this is where it gets tricky. This trash may not fit the criteria, and it might fit the criteria for where you need a warrant. And that's what gets really interesting about it with the trash, because if indeed they searched this trash and they shouldn't have without a warrant, and they got the IgG, the state's in trouble. However, I do think that this would have already been thrown out if that's the case, but we're still looking into it because it's very interesting. So I wouldn't say I wouldn't call it that. I would not call it a dirty prosecution. I would not call it that. It's not. Now okay. Having said that, there are some questionable things coming up. Well, we're going to get to it, right? Because in the motions to suppress, some of the issues from the defense that they raised were founded on, things like overbroad search warrants, okay, or again, like I mentioned, the IgG, or a lot of it really does stem from that, and so a lot of their argument is it's all fruit from the poisonous tree. But there's also like not applying Idaho standards, because Idaho has a higher standard for privacy. There's all kinds of stuff. But I wouldn't say that it's necessarily dirty. I would say that where it gets tricky is things like with Brett Payne, who wrote the affidavit. There's some things there that are funny. There are some questions, right? But I wouldn't say that it's a dirty prosecution. I wouldn't go that far. There's not enough to go that far, I would say, at this point. I think more so what we could say is that you might see a little bit of maybe law enforcement kind of cut corners in order to try to find somebody quickly, because this case became a phenomenon, worldwide phenomenon. It's actually shocking that some of you guys didn't know of this case. It blows my mind. This is one of the highest profile cases I think ever. Maybe only second to Casey Anthony, maybe. But basically there was a lot of pressure for them to find somebody quickly, right? Because they didn't know, right? Like, are people unsafe? Is there a madman on the loose, so to speak? Whatever. So for example, utilizing the FBI, and that this is part of what came up again in the defense's motion to suppress, utilizing the FBI to get like search warrants and subpoenas, because the FBI has a lower standard for in terms of the Fourth Amendment search and seizure. Whereas with states like Idaho and Pennsylvania, and I believe Washington also, their state constitutions have a higher standard. So what it kind of looked like, according to the defense, is that they brought the FBI in just so that they could use them to get these search warrants that are overbroad and don't follow the rules of the state, and then they promptly kicked them out. They promptly kicked them out. They just kind of used them for the stuff and then they kicked them out. Again, big difference, right? When you look at like Casey Anthony, for example, FBI was involved that entire time. I actually appreciate that, right? Because if you're going to involve the FBI and you actually want them involved and you want their help, you should utilize their resources. It is funny when you have cases where they bring them in and then kick them out. Same thing like in, there's other cases where they've done that. I'm trying to think, but I'm sure you guys will. There's a lot of cases, right? We see that. So, and it tends to be in small towns. Oh, Delphi. Delphi is a great example. It tends to be these small towns, right? Delphi did the same thing. And it's like kind of sus. So basically, right, what they find, here's to answer this question about, did he know them beforehand? So here's what we know. So people have speculated about them meeting at a restaurant and all this other stuff. We don't have evidence of that. I'm not going there. Okay. What we do know, because it's come out in the court filings, right, is the evidence that the state is presenting, right? Which what they've been presenting is these cell phone pings. And according to the state, they have these cell phone pings that Bryan Kohberger, and this was, I can say that because this was his phone, right? He had pinged at that house like 12 times prior to the night of the homicides. And it was always in the middle of the night. Okay. And then they have his phone pinging, I believe it's like 3 a.m. in that area. And then it like goes silent. Now, is it in airplane mode? Is it off? We will get all the way into that because there's a huge difference. We talked a lot about that with Murdaugh. But basically they don't have any pings during that exact window when the homicides occurred, right? So the next ping they have them is like back in Washington. And then they had a ping the next morning. Well, I guess technically the same morning because if the homicides were like 4 a.m., right? But like they have a ping in the morning, and this was before 911 was called. So this could suggest that he was back in the area if he did this to see if any law enforcement had showed up yet, right? Other people have speculated, did he come back to get the knife sheath that he left behind? And again, to our knowledge, there's nothing else left behind. Like this person didn't leave any, because here's where we're going to get into the DNA evidence, right? The only DNA left behind from that has, and again, this is the type of thing that the state wants you to know, because there is the gag order, right? But they have to say, here's the evidence against you when they go to charge you, right? So the only DNA was found on the snap of that knife sheath. Now, because of the IgG, right, from the trash DNA, and then they use this to get an arrest warrant. Then they use that to get for a arrest of his person, right, or search of his person, which includes buccal swab. So then what happens is then once they have the buccal swab, right, now they have a known DNA sample from him, and they can say with like a bazillion certainty, to all that standard, that it matches the DNA found on the knife sheath. Now, the DNA found on the knife sheath is touch DNA. So that'll be a whole thing too. So, but the thing that connects, so in other words, the thing that really connects him there is just simply the cell phone pings. It looks, if you go with that, it looks like he maybe was surveilling the house, kind of stalking it. I have looked up, and again, this will be in the presentation whenever I do it, that whenever you find pictures of that house, it looks like the lights were often on. We know the doors were often unlocked. There's also potential he could have even been in the house before, again, because it was a party house. It's entirely possible because, again, we've seen it on body cam that there were strangers partying that they're like, I don't know these people. He could have been in there before. And so, but had he ever actually met them before? We don't know that for sure yet. That's something that we might learn at trial. I don't think he necessarily needed to. Some people have speculated about maybe there was a social media thing. We don't know that for sure yet either. Some of this stuff, there's a lot of rumors. I go off of what we have, hardcore, like what we have in the court filings, right? Public record coming from reliable sources, and the reliable sources that push back, again, two-party system or adversarial system, right? So then they come in, the FBI comes in, and they arrest Bryan Kohberger in Pennsylvania at his family's home. And apparently when they came in there, he was actually sorting trash at the kitchen counter wearing latex gloves or something. So So if you're the defense, right, and if you know, assuming this goes to trial, right, you're going to be wanting to dispute the you're going to want to, you know, to really delve into, of course, the DNA. Although again, that's going to be harder to do potentially. I think that, you know, again, it all kind of comes back to that IDG and if that, what goes on with that. But yeah, and then also the cell phone pings. And again, some of that is questionable, as we know from Murdaugh. When you've got a rural area or a place with fewer towers, it can be tricky because, like in Murdaugh, we know there were times where individuals like in the family were known to be at the house, like at the family's home, and were known to be using their phones. There's no dispute of that, but we're pinging off of the tower in Varnville, which is like 35 minutes away or something. I can't remember exactly, 30 minutes away, but it's quite far away. And meanwhile, there's two towers, at least two towers close to the house. And it's because of the way it works with the triangulation and stuff. Anyway, we'll learn a lot more about that at the trial, but there's a good amount that you can learn from watching Murdaugh, because when they bring in the expert to talk about how that works, the cell phone pings, you get a lot of information that's just how this works before they get into the facts of the case. Anyway, so essentially, and I know this can be the case because we saw this in Murdaugh, but in other words, it could be, right, and this is what they're going to be looking into for the defense, right, that his phone was pinging off of the tower in, you know, closer to the house, but he still could have been elsewhere. And that's kind of what they're kind of trying to say. There was a whiff of trying to use an alibi defense, but that kind of was officially not on the books, and that ship has sailed on that one. But what his defense attorneys were saying was he was out running in some crazy park with some crazy name. He was out running and like stargazing while this was happening. And that would explain why his phone lost service and whatnot. Anyway, so, but it is a death penalty case. And he has public defenders, and his lead public defender, Ann Taylor, is a force. And she's, I have not seen her in trial yet. And there's no videos of her in trial, but her motions practice and hearings and he's got a killer defense team. He's got a defense team that is better than most people when they hire lawyers. And I would say, like, you know, before I started covering Casey Anthony, she was probably my favorite defense attorney, even though I had never even seen her trial. Although now, as y'all know, Mr. Baez is my favorite. But she's awesome. She's awesome. Right. I know a lot of, yep, certainly are a lot. And so this is where I got really familiar with all the litigation and everything with the death penalty, because I covered every single court filing regarding the death penalty in this case. So, and just to show this real quick, let me show this real quick. So this is the docket, okay, for Bryan Kohberger. I always like showing this because it's a lot. Okay, oops. Hold on. Okay. So you 12/29, 2022, you have the affidavit. So now I'm going to scroll. We're still in 2023. Still in 2023. Still, now we're in 2024. So what's been going on in all this was a lot of things, but one of them is like the change of venue, right? That was granted. So that's how they moved from Latah to Ada. So that happened recently. Now here's motions to strike the death penalty. Again, I covered all of these. I covered all of them. Initially, they had 5 aggravating factors against him. The state dropped one, which is a big win for the defense. So now there's only 4 left. And then there's the order grant. That was a big day. The order granting the defendant's motion to change venue. And we're getting close to present time. That's still death penalty stuff. I covered all that. And then here's all the motions to suppress. Look at all these. So these, again, I covered all these in two live streams. Here's all the motions to suppress. Another thing that was really noteworthy that we learned from these is that Bryan Kohberger talked to law enforcement, and apparently he did like an interrogation. We did not know that. That was news. because what they said was that he was interviewed. That's the word they use, right? But after he was arrested, he was interviewed and made statements before asking for an attorney. Now, we don't know what statements or how many. It could be a lot of statements, it could be very few, but he made statements before asking for an attorney. That was news, because everything that we had known prior to that, because remember, there's a gag order, was that he hadn't said anything. And that was what I thought was the case, again, because he had a background in criminal justice. I was sure he didn't talk. And anytime that they were, transporting him and the cameras, I mean, he never said a word publicly. There was one statement, this is hearsay, that somebody from law enforcement said that he asked them, did they arrest anybody else? But we don't know that for sure. That did come up in one of the motions to suppress. Like, there's no way to know that statement for sure. But that if that was said at all, that was the only thing. But now we know that there were statements made when he was arrested. There were statements made in the car, and there were statements made in an interview room. Okay, so that's that. Okay, now we're getting to right. The state asked for more help. They brought in some more assistant attorneys general. That's a whole other thing. We've covered all that, and now we're getting to where we are today. So again, these were from 12/6, but they didn't get posted until like yesterday or the day before. They popped up late, probably because they were waiting on deciding what was going to be sealed, as you can see here. And so they were probably waiting on that, and then all these showed up, backdated, basically. And that brings us to today. What do you mean specifically? There's some similarities so far. Like, the wording in the jury instructions are different. But there are some similarities. This, like, what I would say as far as a similarity is that the jury has to find at least, this jury has to find that the state proved at least one of the aggravating factors beyond a reasonable doubt, and they have to agree on that aggravating factor. So the more aggravating factors you have listed, the better those odds are, right, if you're the state. That's one similarity. And maybe that's true of every state, but again, I'm going through them one at a time. Big difference though, right, is in Idaho, it needs to be unanimous for a death verdict. They need to be unanimous. Whereas in Florida, they only need 8 out of 12. So that's just going off of just some of the things. Yes, it's a lot of filings. I think I may have answered that question. I mean, again, because we kind of went through a little bit, right, with the aggravating factors. Now, remember, Florida has more aggravating factors available to them. I think it was 13. Idaho has 11. And there's some similarities in the aggravating factors and some differences. I guess that could be one thing to compare and contrast as the aggravating factors. But we can let's review the ones for Idaho, since we're talking about Idaho right now. Let me do this. All right. So, yeah, let's take a look at this. Okay. So in capital case, right? So statutory aggravating circumstance. So remember, you've got your statutory aggravators, and then you have your non-statutory aggravators. What is that? That's like victim impact statements, basically. So the statutory aggravators is what the jury must find at least one beyond a reasonable doubt. I'm sure this will say. So, okay, where a person is convicted of an offense which may be punishable by death. Let me see if I can highlight it. So, okay, there now you guys can see where I am. Where a person is convicted of an offense which may be punishable by death, a sentence of death shall not be imposed unless a notice of intent to seek the death penalty was filed and served as provided in blah, blah. The jury or the court, if a jury is waived, so like a bench trial, finds beyond a reasonable doubt at least one statutory aggravating circumstance. Where a statutory aggravating circumstance is found, the defendant shall be sentenced to death unless mitigating circumstances which may be presented are found to be sufficiently compelling that the death penalty would be unjust. Now, that is a key difference in the languaging. That was one of the things I was going to mention. This is going to be we're going to see this in the jury instruction. We heard about this with Chad Daybell as well. So this is specific to Idaho in terms of the differences. This is specific to Idaho. I think this is actually a good way to do it if you're going to have the death penalty, because instead of saying you have to find that they deserve death, basically, right? It's like the other way around. It's like glass half full, half empty, right? So the question is, the question for the juries, are the mitigating circumstances sufficiently compelling that the death penalty would be unjust? So they're not having to say the death penalty is just. If they find for death, they're saying that it wouldn't be unjust. You see that there's a big difference there, because it's still really leaving it up to the court in a way. Like, I think the reason for this is so the jurors don't end up like unable to live with themselves or whatever, feel, you know what I mean? Like, I think this is smart. I think it's a smart way to do it, because I think that it's not fair to put upon people find that they should die, right? You know what I mean? So in other words, it's just the other way to look at it. The jury shall not direct imposition. The jury shall not direct imposition of a sentence of death unless it unanimously finds at least one statutory aggravating circumstance and unanimously determines that the penalty of death should be imposed. So again, they have to be unanimous, but really it's that languaging though that it wouldn't be unjust. That's how they word it in the jury instructions. So let's see here. The jury shall be informed as follows. If the jury finds that a statutory aggravating circumstance exists and no mitigating circumstances exist, which would make the imposition of the death penalty unjust, the defendant will be sentenced to death by the court. Now let's see if it has a thing in here about, or a subsection in here about if the judge can, like in Florida, we know that if the jury finds for death, the judge can overrule that or override that. If the jury finds the existence of a statutory aggravating circumstance, but finds that the existence of mitigating circumstances makes the imposition of the death penalty unjust, or the jury cannot unanimously agree on whether the existence of mitigating circumstances makes the imposition of the death penalty unjust, the defendant will be sentenced to a term of life imprisonment, LWIP. If the jury does not find the existence of a statutory aggravating circumstance, or if the jury cannot unanimously agree on the existence of a statutory aggravating circumstance, the defendant will be sentenced by the court to a term of life imprisonment with a fixed term. Oh, that is interesting. I did not know that. That is news to me. I thought it was LWIP no matter what. This is noteworthy. Let me read that part again. This is noteworthy. Wow. Okay, let me read this part again. This is the important part. So if they find a statutory aggravating circumstance, right? They all agree. And that the reason that matters is because in this case, the one aggravator that they have, well, the one that is pretty much, if he gets found guilty, right? The aggravator they have on Bryan Kohberger that is going to be hard to say is not proven. Multiple victims. It means you kill more than one person at the same time. That it's 4 people, right? So I think that will, if he's found guilty, that's kind of a given. So that could still apply here for subsection B. If the existence of a statutory aggravating circumstance, they find that, right? So again, like for example, multiple victims, but finds that the existence of mitigating circumstances makes the imposition of the death penalty unjust, or they cannot unanimously agree on whether the existence of mitigating circumstances makes it unjust, then LWIP for you. But if the jury does not find the existence of a statutory aggravating circumstance, or if the jury cannot unanimously agree on the existence of a statutory aggravating circumstance, sentenced to life with at least 10 years, not LWIP. Now, again, I don't know that would be the case here if he's found guilty, because again, the multiple victims is going to be tough, but that could apply to other cases, right? Like, in other words, if they've presented them with these statutory aggravators and they are unanimous that doesn't meet any of them, or they can't agree, they don't even get LWIP. Wow. Upon the conclusion of the evidence and arguments in mitigation and aggravation, then the jury shall return a special verdict stating, 1, whether the statutory aggravating circumstances have been proven beyond a reasonable doubt, and if the statutory aggravating circumstance has been proven beyond a reasonable doubt, whether all mitigating circumstances, when weighed against the aggravating circumstances, are sufficiently compelling that the death penalty would be unjust. And then this is if it's a bench trial. But this is the part I was going to go to. Here are the aggravating circumstances in Idaho. All right. So they need at least one, but I'll tell you which ones apply to Bryan Kohberger. So, I have it memorized, but we'll just go through them in order. So here's the first one. The defendant was previously convicted of another murder. So, previous record of murder. Okay, does not apply here. At the time of the murder was committed, the defendant also committed another murder. That is your multiple victims, as they call it. So that applies here. That's one of the ones they have for Bryan Kohberger. The defendant knowingly created a great risk of death to many persons. Nope, not applicable here. The murder was committed for remuneration on the promise of remuneration of the defendant employed by. Okay, that sounds like you hired somebody to do it or something, right? The murder was this is the hack aggravator, especially heinous, atrocious, or cruel, manifesting exceptional depravity. I've ranted enough about how I feel about this one. I'm not going to do it again now, but this is one of the aggravating factors for Bryan Kohberger. They call it the hack aggravator. By the murder or circumstances surrounding its commission, the defendant exhibited utter disregard for human life. Another one I've ranted enough on. I hate this one as much. This is the utter disregard aggravator. This is the third aggravator they have for Bryan Kohberger. So far we have 3: multiple victims, hack, utter disregard. The murder was committed in the perpetration of or the attempt to perpetrate arson. This is the felony murder aggravator. This is the one that they had and they dropped it on Bryan Kohberger. The murder was committed in the perpetration of or attempt to perpetrate lewd and lascivious conduct with, so that's like SA stuff. That is not applicable here. The defendant, by his conduct, whether such, this is the propensity or future dangerousness aggravator. And this is the fourth one they have for Bryan Kohberger. Propensity to commit murder, or will probably be a continuing threat to society. Again, as you guys know how I feel about this, right? LWOP should do it if that's what you're worried about, but whatever. This is the death penalty aggravator. Threat to society, continuing threat to society, future dangerousness. That's the fourth one they have on Bryan Kohberger. Then as far as the last 2 aggravators for Idaho, the murder was committed against a former or present peace officer. Law enforcement, blah, blah. Or the murder was committed against a witness or potential witness in a legal proceeding. So that's Idaho. You're all right. You ask away. Ask away. Feel free. Anybody who's watching, feel free to ask any questions you have. I will answer them to the best of my ability. I'm happy to do that. If anyone's new here, welcome. I am a teacher by nature, so I love answering questions. No squirrel left behind, I will say. So, okay. So that brings us back to, all right, the prosecution, the state. Okay. So the state objects. All right. So it's still being filed from Latah County because that's where the prosecuting office is, even though the trial's being held in Ada. All right. So state's objection to defendant's motion to suppress commander. So this is so remember how we saw the motions, we went through the docket. You have a motion to suppress for each particular, instance or item, right? So this is for the defendant's apartment. So this would be the apartment in Pullman, Washington. Okay. Defendant's apartment. So remember when they went there, he wasn't there because he was at home for the holidays, as it were, right, in Pennsylvania. And so he was arrested right before Christmas or right after Christmas, I think. Or no, Thanksgiving, I think. Anyway, so all right. I think it was Thanksgiving. All right. So it was, because I remember there was a whole thing about were students going to come back. I think most students stayed. I think the students didn't come back after Thanksgiving. I think they stayed home all the way through Christmas. Yeah. Okay. Because they didn't know yet what was going on and if it was safe. Okay. So the defendant's instant motion regarding the search of his residence in the state of Washington substantively parallels his motion to suppress Pennsylvania search warrant for. Okay. So this is the search warrant for his parents' house right here. That's a separate motion, right? So what they're saying is this is very much similar. The Pennsylvania search warrant for Mr. Kohberger's person and the Pennsylvania search warrant for the defendant's vehicle. I don't disagree because a lot of what they are saying in those motions to suppress is it's all fruit of the poisonous tree. So that applies to everything. To avoid unnecessary repetition, the state incorporates herein the state's objection to defendant's motion to suppress and memorandum in support Pennsylvania search warrant and statements made. Key there, right? which itself further incorporates the state's responses to the defendant's Franks motion. Oh, yeah. Another overlap here, right? I forgot. Well, I've talked about this before, but I haven't said it tonight. Another similarity here with Delphi. They have made a motion for a Franks hearing, and the judge has signaled so far that that's gonna happen, Franks hearing. So this is the one, some of the things that are under seal recently from the defense were the motion for the Franks hearing and motion to suppress genetic information. Now, let me see here. Hold on. What was it? So it's like we saw that they filed for that, but like everything, all the information is like, let me see this real quick. So yeah, so what happened was, okay, right. So so when they filed the motion for the memorandum for the Franks hearing, right, it was over 2,000 pages. And so, yeah, we didn't have that. And what happened was Judge Hippler could have flat out said, it's too long. You didn't tell me where to look. It's overbroad, like, 38 exhibits over 2,000 pages. And instead what he did was he said, hey, can you please just let me know where specifically I need to look in here? And he's giving them a second chance to file, to like help him out, basically. That, again, to me, signals that he wants to be able to do, like, help me help you, right? I was shocked because he's been kind of a stickler. In fact, I've called him Judge Stickler instead of Judge Hippler. So, right. So anyway, so yeah, so the Franks motion and then the motion to suppress IgG, those are under seal. Everything with IgG is under seal. Okay. So, but this is what's so funny. Regarding the defendant's represented facts, in scare quotes, all caps. By the way, the state says this in every single one of these objections, which is really funny. This is where we get a little bit of this going on. Okay. Regarding the defendant's represented facts, and as opposed to relying on defendant's subjective summary and interpretation, the state respectfully refers the court to defendant's Exhibit A in support of his motion to suppress research warrant for defendant's apartment, filed under seal. The state notes that the defendant's referenced Exhibit A, for some reason, does not include copies of the actual state of Washington search warrant. Oh, but guess what, guys? I have that. I have that pulled up for different reasons. I didn't even know that was going to be noted here. I have it. I have that. I have it already ready to go. Applicable law. In his memorandum at page 5, the defendant discusses what should be the applicable law. Right. So this is a big deal, right? I've referenced this already tonight, but we've talked more about it on the other live streams because of the fact that each state has its own constitution, right? And as far as the Fourth Amendment, right? Search and seizure, you can add, but you can't take away. So not the FBI, oh my God, the federal government, right? We have the U.S. Constitution, and that's the bare bones. Every state has to have at least that, but you can add to it, you can't take away. So some states have more specific laws in place in regards to the search and seizure. And two of those states are Idaho and Washington, and I believe also Pennsylvania. But Idaho, they've cited in the motions to suppress, Idaho actually has, it's like in quotes, like Idaho's uniqueness. It was joking because it was really funny that came up so much. Idaho's uniqueness. Apparently Idaho, according to the defense, has a really especially heightened standard for protecting people's privacy. So anywho, this is the same discussion that the defendant presented in his various motions regarding search warrants from Pennsylvania. Similar to the state's response to those motions, the state acknowledges that there appears to be little, if any, substantive differences. So they're like, we're not going to bother because they are so similar. Valid search warrants. Beginning at page 7 of its instant motion, the defendant asserts that the affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material information. Right, he did assert that. Substantively, this section of the defendant's motion merely refers to the defendant's separate Franks motion or an argument. By way of preliminary response, the state notes that Idaho law clearly states that if, quote, a search is conducted pursuant to a warrant, the burden of proof is on the defendant to show that search was invalid. Yeah, we know. They said that as much as well. Idaho recognizes the United States Supreme Court's analysis in holding that the great deference is paid to the magistrate's determination for probable cause. This is the back and forth. Because this whole thing with the magistrate, that came up in the motions to suppress, where there were issues there. What was it? I believe part of it was that because they utilized the FBI, I think that was part of it too. By utilizing the FBI, I think they get to go around having to have a magistrate take a look at it. And additionally, they can make it overbroad. So there's going to be argument on this. There's going to be argument on this. Mark my words. As demonstrated by the Washington search warrant and amendment, the search of the defendant's residence was done pursuant to specific Washington court issued search warrants based on substantial probable cause. You know what? All right, it's super relevant now. Let's pull up that search, Washington. So it's so funny that I had this already. Let me unshare, reshare. All right. It's 49 pages, but we're not going to go through all of it. So, all right. So this is the motion in order to unseal warrant return. Basis. These warrants were issued and served in Washington state because a suspect in the crimes resided and worked here during the times of the murders. These warrants and associated applications were sealed due to the sensitive nature of the investigation at the time. Since then, an extensive probable cause affidavit has been unsealed in Latah County, which has alleviated the need for sealing of the return of service here in Washington. Okay. Motion to order for original search warrant and search warrant application to remain sealed, but a redacted version be provided for public release. Okay, fine. So in other words, they're going to redact names of people in it, probably victims and survivors. Okay, fine. Okay, now here is the redacted search warrant. All righty. In making this determination, this court did not consider the information in the supplemental disclosure re-DNA test as evidence supporting the existence of probable cause. So what they're saying is they had probable cause for this search warrant because there was probable cause to believe that crimes had been committed per Idaho code. And that things could have been concealed on the premises where the suspect lived. Okay. So here we go. So this was the apartment, right? Pullman, Washington. It's 3-story multiple occupancy apartment building in Pullman, Washington, which is tan and white in color. Apartment G201 is located on the northeast corner of the second story of the building. The door to G201 is located on the east side of the second story landing and is designated by 201. They have to put all this so that the problems that would arise if they accidentally go and search the wrong thing are vast. So this is all really important that people search the right thing. That's why they have to make sure that there's no question. Look at how it's specific. All right. Seize if located evidence of the above listed crimes, including. All right. Here's what they're looking for. Who is Frank? Great question. So that is coming from case law. And they did this in Delphi, right? So this is from let's see, where is that? Let me find this for you guys. So it comes from Franks v. Delaware. So I think I've covered that on, I believe, on this channel. Franks v. Delaware. It established legal standard for challenging the validity of a search warrant. So let me just pull up that real quick. So Franks v. Delaware is from 1978. Okay. So Supreme Court, right? So basically, a knife found, interesting, right? So basically, it's a motion to suppress, right? On Fourth Amendment grounds, items of clothing and a knife found in the apartment because of challenging the truthfulness of certain factual statements made in the police affidavit supporting the warrant to search the apartment. So here's basically what it is, right? Is like when law enforcement is providing information in an affidavit to support the return, to support the magistrate, right, signing off on a search warrant. Let's say that's granted, they get their search warrant, and then they go and find things. What this was groundbreaking on is that here, where the defendant makes a substantial preliminary showing that a false statement knowingly and intentionally or with reckless disregard for the truth. Knowingly and intentionally or with reckless disregard for the truth was included by the affiant in the warrant affidavit. And if the allegedly false statement is necessary to the finding probable cause upon which they get a search warrant, the Fourth Amendment, as incorporated, requires a hearing be held at the defendant's request. And so in this case, the trial court erred in refusing to examine the adequacy of the petitioner's proffer of misrepresentation in the warrant affidavit. To mandate an evidentiary hearing. So it is, again, Frank's hearing is an evidentiary hearing. And the defense is going to have to provide evidence, right? Again, that law enforcement made false statements knowingly and intentionally, or the or is important, with reckless disregard for the truth. So in case it's not knowingly and intentionally, if it's a reckless disregard for the truth, and those statements were used to get probable cause for a search warrant, then you get to have this hearing to challenge that, because what they're saying is that search warrant was like made under false pretenses essentially, and anything found via that search warrant shouldn't come in. So, right. If after a hearing, a defendant establishes by preponderance of the evidence that the false statement was included in the affidavit by the affiant, knowingly and intentionally, or with reckless disregard for the truth, and the false statement was necessary to the finding of probable cause, then the search warrant must be voided. And the fruits of the search, fruits of the poisonous tree, excluded from the trial. So thinking about the fruits of the poisonous tree thing, right? They've got two things going on here, right? They've got the IGG, right? But then they've also got this Frank's motion for Frank's hearing, right? Where, and again, a lot of that is under seal, but that is a separate, but what is the right word? Like two issues at the same time, two different issues at the same time. So in other words, as far as all these motions to suppress, right, and the fruit of the poisonous tree, they're hoping that it could be found on the grounds, like things, like items of evidence, pieces of evidence can be suppressed on the grounds of, the fruit of the poisonous tree because of the IG, but also it could be and or anything that comes of this Frank's hearing, if in fact the officers in the affidavit, again, knowingly and intentionally or with reckless disregard for the truth, provided information that was used to get probable cause for a search warrant. And then things were found via that search warrant. So that's the Franks. Okay, good night. Good night. Good night. Thanks for being here. Thanks for being here, everybody who's here. And again, for anyone who's going to be on replay crew, of course, y'all know I'm going to have timestamps. I'll say it again, just in case anyone's wondering, sometimes they don't appear in the scrolly bar. So if you don't see them, check the video description, because I always do detailed timestamps for every video. All right, so let me go back to this. Okay, so, all right, so seize if located, evidence of the above listed crimes, including blood or other bodily fluid or human tissue or skin cells, knives, sheaths, or other sharp tools, including any dagger, dirk, or sword, right? Any images, whether digital or on paper, which show, and these are the victims' names, right? Ethan Chapin, Kaylee Gonzalez, Xana Kernodle, Madison Morgan, and then these are the initials of the survivors, DM and BF. And DM is the one who saw the suspect. And or the house at 1122 King Road, Moscow. Also just want to say, we, rest in peace, Ethan, Kaylee, Xana, and Madison. And it's horrible. It's horrific what happened to them. It's absolutely horrific. Absolutely horrific. Yeah. So clothing including but not limited to dark shirts, dark pants, mask, shoes with a diamond pattern sole. Oh, right. Because there is a footprint that they did find at the house, a bloody footprint. Yeah, that's right. the bloody footprint. Right. But yeah, trace evidence, including DNA from blood or skin cells, data compilations showing an interest in, what does this look like, right? 403 waiting to happen, 403, 403 analysis, an interest in, like, check, y'all, look at this though, right? Oh my God. An interest in or planning of. Okay, planning of is one thing, but an interest in, like, the thing is for anyone who watches trials, right, and has an interest in the law or true crime, whatever, we all know that you could, if they were to do a digital, dump of all the data from our devices, right? They would see enough to say, yep, they've got an interest in, right? So this is why this is really stupid, because we all know we're not out murdering people, right? That doesn't, planning of is different. Like, that's why this is silly, because honestly, these are two completely different standards. Anyway, yay, glad to see you, Angel Baby. Long time. Oh, what? How? I didn't know that. I don't know how I didn't know that. What? Did this just come out? His son. What? Do you have any more information about that? I'm so sorry to hear that, because his son was such a big part of that channel and was getting more and more involved. And Michael Rivers, right? That's his only son, right? Or does he have also a daughter? I'm trying to remember. But it was his son who helped him with the show, right? Oh my God. I'm pretty sure. Yeah, okay. That is really sad. I'm so sorry. I'm sure Bruce Rivers will never watch this, but my heart goes out to him. I have to say that I really love him, and I loved his son. I thought that they had such heart. Dude, I am devastated by this, because they were so close. This is unbelievably heartbreaking. Oh my God. They were so close. There is not an episode of Bruce Rivers on his channel where he doesn't almost get teared up every single episode when he goes to, like, thank his son or talk about his son. Like, I can't even. Oh my God. Can't even wrap my head around it. That's awful. Wow. Do they know how? Yeah, and you know what? I guess now thinking about it, now I realize I hadn't seen a video from him in a while, and now that makes sense, right? Because usually if he's got a new video, it pops up like on YouTube. You know how YouTube does that. And I hadn't seen one in a while, and that explains it. I don't even know how he's going to cope with this, to be honest with you, because wow, his son was his life. That is horrifying. I mean, was it an overdose? I can't fathom, I hate that because of the age, right? It's like, well, fucking hell. And the thing is like, I can't imagine that if he had a drug issue, his dad wouldn't have been privy to that and gotten him help. Anyway, this is just crazy. I don't really know. I can't. Anyway, that's terrible. Thank you for letting me know. And that's awful. So we do also have a new squirrel friend named Erin, who, well, I guess she'd been a long time watcher, but just recently started getting in the chat. But she lives in I believe in Minneapolis. She lives in Minnesota. I believe it's in Minneapolis. But she's not. But no. Don't be sorry. Don't apologize. The point of live streams, people, is for you guys who feel so inclined to chat with each other and or me. That is the point, right? That is why we go live. So it's more fun to interact with people. So I don't know. Everyone always apologizes, and it's like, no, please. That's the point. Oh, and okay, right. I'd forgotten that as well. Okay, I'd forgotten that. I'm sorry. I think maybe because you moved, if I recall. But yeah. So wow, that is awful. So. It's like, the thing is like, parents, every parent loves their kid. And obviously what I will say about this is they had a really special relationship for an adult father and son. But not only that, they were working together every day. Like, this is just really hard to wrap the head around. Right. You don't live there anymore. Right. That's what I thought. Yeah, our friend Erin talks about all the very Minnesota specific things. Like, she said she has 7 crock pots. It's really funny. We always joke about that with crock pots and the food. Okay, so yes, so data compilations. But yeah, but what I was saying, where I was here is this whole thing is so silly, the interest of, right? It's like, all right, that, yeah, we'd all be locked up if that was enough. Okay, books, blah, blah, electronic digital devices, evidence of other accounts, photographs, all the stuff I feel like is just, kind of run of the mill. Evidence of device using to conduct internet searches, relating to our view of other murders. I mean, the other thing is this, right? Because of the fact, like, especially in his case, right? Like, those of us who follow these trials, we've probably looked up searches about other murders, right? Because it's a case. But especially as it pertains to Bryan Kohberger, because he was stressed on studying criminal justice, there's going to be this, right? Even if he had never killed anybody, that would have been there because he was studying under Dr. Ramsland. But anyway, information that could be used to calculate the position of the device, so like GPS, evidence of the identity of the person in possession of the device. So one thing that, because we were talking about the car and the phone, one thing that they're going to have to do, the state, is place 3 things together, because, there's going to be an idea, right? That, okay, you've got the phone and the locations of the phone. Now there could be issues with that because of the towers and whatnot, but even if you can pinpoint that, you got that. And then you've got the surveillance footage of the car. But what you have to do is you have to place Bryan Kohberger with both of those devices, and then all 3 together. You have to place Bryan Kohberger with the phone and with the car, all 3 together at the same time, right? That's what's going to have to be done. And that's where it could get tricky, because, they could make an argument, the defense, and it's reasonable, right? Because someone else could have had his phone, someone else could have had his car, stuff like that, whatever. There's a bunch of different things, but they're going to have to place all 3 together. So yeah. Like how they did that with Alex Murdaugh, for example, because that's a great example, right? When you look at that beautiful timeline, the best timeline ever, because they had, the way they were able to do that with his vehicle activity and his phone was because he was making phone calls, right, to people. He was using his phone. And so you didn't just have GPS and like iPhone location data, but you also had cell phone tower pings. And then you had the GPS data from the car's infotainment, the OnStar, right? Now, it was harder for them until they got that data mid-trial. Anyway, but then that had its own set of GPS coordinates, right? And then they were able to say they matched. So that he made this. So in other words, it's like he didn't just make this phone call at this time. When he made this phone call, here's where he was in the car driving. That was him with the phone with the car, right? All that. Like that they had it on lock with that timeline. That's how you do it. That is an example of how you have all the information and you can lock it down, right? Person, car, phone. But you can't, not every case has that, right? So, okay, passwords, indicia of residence, assistance from any law enforcement agencies, promptly return this warrant. Okay, so then here's the application for the search warrant. On the basis, right, of the following, I believe there's probable cause. Now, why does this matter? Remember, Frank's hearing. Now, we don't know. I mean, I think that they included this in that, right? So remember, it could be any, because you're going to have these in 3 different states, right? So one of them or all of them need to fit that standard as we just referenced in the criteria for a Frank's hearing. And, again, this would be an example where we could see this, right? Are there statements in here that are knowingly or intentionally false or made with a reckless disregard for the truth? Now, we may not know the answer to that, but that's just the standard. Keep that in mind. I have probable cause. I believe there's probable cause crimes committed, and that evidence of those crimes, weapons or other things by which the crime may have been committed. By the way, again, because there's been some people who are kind of new to this case, they still haven't found the knife to our knowledge. And I think if they had found it, we would know, because it would be, we would see there would be reference to it in these filings for sure. So the knife. Oh my God, the knife was never found. So what they did not check the boxes for contraband or a box for the person, because they knew he was not there. He was in Pennsylvania. And there's the apartment. And here's the affiant. And so, see, they're relying on Sergeant Blaker's sworn statement. Now, what I recall learning from the motions to suppress is this sworn statement is based on the affidavit. So essentially, it looked like, from what we saw, everything is based on copying and pasting the affidavit from Brett Payne. So I really think that what they're going to be trying to say, the defense, is like that's where the issues lie. And then that, because that affidavit was copied and pasted into everybody else's sworn statement, and then those sworn statements were used to obtain search warrants. Again, they're all same, right? They're all based on that. So if it's wrong in one place, wrong in another place. I was contacted by Moscow police officers. Okay, the probable cause is described in detail in Exhibit A. It's the sworn statement is Sergeant Blaker. Again, I believe it's going to be much of Brett Payne's statement, so we'll see. And this is just listing all the things. This is exactly what we already saw. Let's see. Supplemental disclosure, re-DNA test. I have been informed by Detective J.R. Talbot of the Idaho State Police that, 1, on November 13th, 2022, a sheath was recovered at the King Road residence, under or next to the body of Madison Mogan. The Idaho State Crime Lab obtained a male DNA suspect from the sheath. Now, remember, what would have happened here is initially it would have been put into CODIS and there was no match, right? So this is what they used. Well, let me not get ahead of myself. Let's go in order here. It's also referred to in Sergeant Blaker's sworn statement. Okay. Oh my God. Oh my God. I didn't even know that it was going to bring up the trash. Thank you. Thank you, document, for bringing up the trash. I can't believe they're bringing up the trash. Great. Maybe we'll learn more. All right. On December 27th, 2022, so it was after Christmas. Okay. Law enforcement agents, officers in Pennsylvania recovered trash that originated from the Kohberger family residence. Originated. This here, again, could be languaging that suggests it could have been in the neighbor's trash can. There's so many issues with this trash. My brain. Originated from the family layer. Now, again, why am I saying that? Because if, we know he was seen throwing his trash into the neighbor's garbage can. That's how they could use this language, right? Jesus Christ. But then the languaging differs in other documents. That's what's so weird, because some of them literally say it was actually their trash can. All right. The trash was sent to the Idaho State Crime Lab for testing. On December 28, 2022, the Idaho State Crime Lab or Idaho State Lab reported that a DNA profile was obtained from the trash. It was compared to the suspect's DNA profile. Okay. My understanding of this was different. Let me know if you guys had this. This is, my brain is going to explode. Because, again, in court filings, okay, the languaging around the trash and the getting of the DNA, there's differences. There's discrepancies. Okay. The reason I said, let me not get him ahead, that's really fucking funny. The reason I said, let me not get ahead of myself. Now, let me tell you what I was going to say. Oh, boy. Because this says they obtained a male DNA profile from the sheath. What I was going to say is that then they took that and matched it to the dad's DNA. But I said, wait, let me not get ahead of myself. I didn't say that. I thought that. Because I was like, wait, I don't think that's what happened. Because I thought that what happened was, see, again, is where it's like iffy. Well, I thought that what happened was they took the dad's DNA, and through IgG, they went and found Bryan. This is a problem for the state. Oh boy. Okay. What we're about to talk about is exactly the heart of what would be under seal with the IgG, among other things probably, but this is different than what this is different. Wow. Because And they had hearings, right? Previously, some hearings were closed, but others were not on the IGG. My understanding, interesting, was that they had the dad's DNA and they, through IGG, right, traced it to Bryan Kohberger. And then once they obtained a buccal swab from him, they matched. They used that to then as the grounds for the rest of the search warrants, including the search warrant of his person. And then upon that search warrant, they take the buccal swab from him. And then they matched the buccal swab to the DNA on the knife sheath. Do you see the difference? Because that order of events, as I described, would be fine. Like, that's a normal chain of events. The only problem would be there is if there was some problem with the trash, which we're still potentially a thing, right? But let me say that again, because this matters. If they start, the difference is where are they starting from? If they start with the dad's DNA and then through IGG, they trace it to Bryan Kohberger, and then they use that to get a search warrant for his person, and then they use that to get a buccal swab test, and then they test that to the DNA on the knife sheath. That is one thing. If instead, oh boy, if instead they have the male profile from the knife sheath first, do you see how now the order is being reversed? Oh boy. Oh boy. Yeah, this is a thanks for being here, by the way. You're very welcome. So where is my mouse being stupid? Hold on. Yes, you're very welcome. So this is where it gets really confusing. The idea was supposed to be that the IgG was done on the sheath sample. I thought the IgG was done from the dad's DNA in the trash. That was my understanding. But this is, as we're seeing, this is like different conflicting information on these. So you can see why there's a lot of back and forth about the IgG, right? And again, part of the trouble is a lot of it is sealed. So there could be a number of issues here, right? And now, okay, here, what do I mean by this? So again, if they start with the knife and work backwards, they've gone in reverse order. So the problem is this: you cannot start with who you think did it and then find proof to support that. You guys know that, right? But what you're supposed to do is start with the evidence and then let that lead you. That's where this matters, because if you start with the knife sheath, right, and you start with that, and then, okay, and then use that. You know, I think that the IgG thing, though, I really do think it's been mentioned both ways. But again, it's so much of it, it's hard to tell. They have mentioned it surrounding the trash. They have mentioned it. Let me pull up. Hold on. Let me do this. Let me pull this up just because this is really important. But you can see how, here's the thing though, regardless, that's a problem in and of itself, right? Like if the state has said, yeah, we use the IgG when it comes to the dad sample in the trash, but then there's also been talk of using it from the knife sheath, then this is getting fishy, right? Because okay, hold on. Let me pull this up. Wow. We need this one, and we need, I'm finding the documents here. This one. Okay, let me unshare, reshare. This is crazy. And these details matter so much. Which one is this one? Which tab is this? Which tab is this? Okay, that's this tab. Okay, which one is this? I have so many documents, you guys. It's insane. Okay. because I remember specifically the ones that seemed to mention the trash the most. So let's see here. Okay. Magistrate in Pennsylvania. Interesting. Okay. Well, we can't. I'm okay. I got to stay focused on finding the thing I'm looking for here. So there's the cast data. It's a whole other thing. That whole thing. There's a dispute about that last trip on the next day. That's a whole other thing. Aha, yeah, okay. The affidavit shows that Sergeant Blaker of the Moscow Police Department requested the assistance of the WSU Police Department, right, in investigating this case. Okay, hang on. Yeah, I mean, these just to reiterate, a criminal defendant may challenge the veracity of an affidavit used to obtain a search warrant. Okay. Okay, let's just review this. Okay. All information in the affidavit was gathered because of law enforcement's unconstitutional use of investigative genetic genealogy, and thus nothing in the warrant should remain. So the question is, right, what we're talking about here is like, again, it seems like we've heard both things, that the IgG was done from the DNA from the trash, but also that the IgG was maybe done from the knife sheath. I mean, they wouldn't have done both. So this is a thing. Mr. Kohberger has argued in a separate motion, filed under seal, that the genetic genealogy investigation in this matter was done in violation of the Constitution. Now, this is very broad, right? I don't think they're just saying this like it's in violation of the Constitution, right? The thing is, remember, a lot of this is under seal. I think there's specific things, and a lot of this could pertain to exactly what we're talking about. Is this related to search and seizure? Probably, Additionally, he argues that there would be no investigation into him. This is where we need, no investigation into him without that original constitutional violation, fruit of the poisonous tree. It is not that the results of the IgG sped up the investigation. Instead, they focused the investigation on Mr. Kohberger. So whenever they've been asking the question, or anyone's asking, how did they connect? How did they find him? Right? It's like, well, initially the Elantra, right? That's my understanding. But then my next response to that was through the IgG, and my again, the next part of that was the IgG taken from the trash. But I think that it's, I feel like that back in the day there was talk of the IgG from the knife sheath, and I'm not saying one is wrong or one is the other. It's just hard to know because again, there's conflicting information as it pertains to some of the stuff, and others is vague, and because it's under seal, right? Without IgG, there is no case, no request for his phone records, no surveillance of his parents' home, no DNA taken from his driveway in a gated community. So again, this here would imply it was from his own residence, not the neighbors. Subject to a refuse removal ordinance, blah, blah. Okay, let me go to the next one. This is getting more complicated. I didn't think it could get more complicated, but it is. This is the home in Pennsylvania. And this one, they've got both grounds here. They've got fruit of the poisonous tree from illegal arrest. That would be going back to like, IgG or, false statements made in the affidavit, that type of thing, right? They've got two different grounds on that one for Fourth Amendment violations, or should be suppressed as a Miranda violation. I don't know that that's going to get them as far, although this was news to us that he had made statements at all, but it seems like, I don't know. I'm not going to side tangent on that right now because that's a whole, there's so many issues. It's just like, got to stay focused on one issue at a time here, right? We're looking for IgG. So, okay. So everything is an issue. probable cause. Here's the part about the interrogation for anyone who missed it before. Finally, during interrogation, before requesting an attorney, Mr. Kohberger made statements to the interrogators. But I think he'd already been Mirandized at that point. Again, we're not gonna work. We've covered it. I'm not gonna go back into all that, even though it's like tempting to. So okay. Establishing that he had standing as a guest there. I don't think that's going to be a problem. There's really no question about that. He's standing there. Why is this here? Franks. This is for Franks. This is literally the Franks standard. The affidavit. So basically a lot of this in terms of the Frank stuff is going to be about challenging Brett Payne's affidavit. That's what it comes down to, because that affidavit was used for, again, through the points, the affidavit was relied upon for like literally everything else in this entire case. So far, they've not mentioned any Brady violations, so at least that's good. All right, all information in the affidavit was gathered because of law enforcement. But you know what they're not doing is specifying where the IgG came from. And maybe that's why sometimes it seems like they're referencing the trash. That's what I thought. And then, but then as soon as I saw this comment about the knife sheath, I was like, oh yeah, that's right. But see, I remember this knife sheath thing. This is my recollection. Now, this is just this is my recollection from like a long time ago that people thought that, but it could still be true. They're not specifying, right? I know, right? Totally agree with you on that one. Mr. Kohberger has argued in a separate motion that the genetic genealogy investigation doesn't matter was done. You know, I think I did say, hold on, let me think. I think I had pulled up a document that has to do with the IG. Let me finish going through this and then I'll go take a look. Right, now I'm remembering. So I had gone back. Okay. Yes, I did do that, didn't I? I'm just thinking to myself. Okay. Eyebrows. Okay, hang on. So maybe it is the knife sheath then. But see, again, without IgG, there is no case, no request for his phone records, surveillance of his parents' home, no DNA taken from the garbage out front. See, this is where it gets confusing. Here's why this is confusing. Because they did not have a search warrant for the garbage. So this is not saying that the IgG improperly gave them a search warrant for the garbage, because they did not have a search warrant for the garbage. So what do they mean by this? This is so weird. Maybe this is saying that the IG, I mean, this is just, they're not spelling it out. But maybe what this is saying, y'all, is that the IgG, maybe it is the knife sheath. They did the knife sheath, right? And then through IgG, they were able to trace it to the dad. But that doesn't make any sense either, though, because if all they do is they trace it to the dad, they don't need to get the trash. There's no reason for the trash, right? The dad trash. We'll call it the dad trash. There's no reason for the dad trash. If they already can trace it. So something's not adding up here. What am I missing? Like, that's why my understanding, the thing with the dad trash, right, is where you can see where IgG would be necessary there. Again, my thought was if they were, I figured they were still waiting on the DNA results to come back on the knife sheath, right? Because that takes time. That takes time. That's the other thing that's weird, because they did. When did they get those DNA results? Because the thing is, I don't think they could have gotten them. Okay, so November 27th is when they pounced on him at the house. Or wait, sorry, 27th is when they did the trash, I believe it said. So I don't know that they would have had the DNA results from the knife sheath yet. No, those were later, weren't they? Oh my God, let me see if I can find an answer to this. This is really crazy. When did DNA results. Yeah, June, y'all, here we go. June 21st, 2023. Well, hold on. Fucking hell. This is, look at this. Look at this. Look at this. This is why we're all confused. Look at this, guys. Because my initial search, it said, look. June 21st, 2023. So this is when they performed the Kohberger DNA to the knife sheath DNA. Okay, so then the knife sheath DNA could have come back sooner. So here's what this says, right? And I know this is just AI, but like we'll take a look at the links, right? This is probably going to be conflicting stuff in here. And this is what's so stupid. This says DNA results from the knife sheath in the Idaho murder case were used to help identify Bryan Kohberger as a suspect shortly after the DNA was submitted. So this here, if this is true, is saying that the DNA from the knife sheath was used to identify him as a suspect. That statement alone, I thought was what the rumor was, but that was not true. Because if that's true, that doesn't work that way. That's backwards. Like that right there is no. That's not how IgG is supposed to be used. DNA from the knife sheath was submitted to the FBI's. When was this? NBC News. I don't want to link to NBC. This is what is so stupid. I wish this was in the documents. I hate this. I don't want to rely on the media. DNA match was found to match. Okay, wait. DNA match was found between the DNA from the knife sheath and DNA from Kohberger's father. So this is why. So it's all meshing together. Like, let's just overcomplicate things, shall we? No wonder so all things are true. This is a disaster. So this is where the trash and the IgG come in, right? Because in other words, like this isn't true because they're not a match. Like let me just make sure I'm clear. Like this says they're a match. If they were a match, it would mean the dad did the crime, right? I swear to God. This is, oh my God. Okay. Because like, if this is misinformation, it should state that they were close enough or similar to see that it was a relative. And why does that matter? Because if that's what you've got, guess what you need is the IgG part, right? That's where the IgG comes back in. Relative, right? That's the thing. And that's where that you can see why it was both things are true. IgG would have been used to match, and this is a problem. So used to match, so it's both things. It's both things. IgG would have been used to match the knife sheath to the dad, and then IgG would also be used then to match the dad to Bryan, and then ostensibly the knife to Bryan until you get an actual match from a buccal swab. A direct match, right? That's it. The direct match. Wow. I can see why the defense is like, because what all this points to, it's like circular reasoning. It's like you need one thing to prove the other thing, to prove the other thing, to prove the other thing that you think is true, but like the first thing wasn't proven, if that makes sense. It's like, remember when I was like, the reverse needs to be the case? It's like backwards and forwards. It's like, what's going on here in terms of the order of events? It's like backwards and forwards at the same time. That's the best way I can describe this, to my understanding. Do you guys see what I mean? Yeah, the dad trash. And here's the thing. Here's what my takeaway from this, right? Because everyone is innocent until proven guilty, obviously. Here's the thing. I understand local law enforcement was under this is why I think the pressure is not a good thing. Same thing happened with Delphi. I knew when it was like the anniversary of the death or whatever, and it started coming up in the media again. And I remember seeing like them coming out saying that there was so much public pressure. This is in Delphi, mind you, right? That there was so much public pressure. And I remember them coming out and doing a press conference, and they were like talking about the pressure. I knew it, that I got a pit in my stomach at that moment. And I was like, nothing good is going to happen here. And then it was like right after that, they're like, yep, we got him. It's these small towns that don't have a lot of resources, and there's a lot of public pressure. And I'm not saying this happens every time, but you can see how even if people mean well, okay, I'm not saying everyone means well. Some law enforcement, I'm sure, does, some doesn't. But even if you assume everyone means well, you can see where people will try to find shortcuts or circumvent things because of the pressure, but also maybe with their intentions being because people feel unsafe. I get it. No one wants to have, you don't know who did this, right? And anybody could be next. No, terribleness, right? Here's the problem, though. If this appears the way it appears, which is like, I don't know, because you can't just do it. You can't just, again, the backwards, forward, circular thing, as I explained, it's, and you did it backwards, and now you're trying to say it's forwards, but it was really backwards because you already had somebody that you thought did it, and now you're trying to match everything to that person. Honestly, it's just like what they did with Casey Anthony. But anyway, what you have is a problem now that if he is the person that did it, rightfully so, okay, things can get thrown out and things because of constitutional rights, because of all the stuff that we're seeing the defense filing, right? Like, in other words, it sucks, right? If you're law enforcement, if you're the prosecution, you want a solid case, but also law enforcement especially, right? They've got this pressure. And then, like, what nobody wants an innocent person to be convicted, and nobody wants a guilty person to go free, right? And the problem is that, justice depends on a lot of things. And the first thing, if you go in chronological order, the first thing is law enforcement doing it right. And you know what? Here's the thing. I think that even if it takes longer, it's worth doing right. It's worth doing in a way that will not violate anybody's rights, in a way that is above board, follows the rules, and will hold up under scrutiny by a good defense attorney, because you should assume there will be one, and that it will hold up and make it to trial and result in a conviction if you have the right person. It is worth taking a little more time or bringing in extra help, because we all know that these small towns are reluctant to do so, at least, or we just bring them in quickly and then kick them out, right? Both Delphi and Moscow did that. Again, I'll just reiterate another thing that's so crazy, right? You look at something like Casey Anthony, because I'm covering that right now, gavel, Orange County, right? They have Orange County, all the resources, all the experience, right? Huge, huge county, countless homicide cases, right? And I applaud, right, that in that case, they brought in the FBI immediately, and they stayed all the way. They used the FBI the entire case. And I'm sure, there's other examples, but just because it's just been coming up recently, right? Because even the defense's case in chief is mostly FBI agents who were there from the state. And the FBI was utilized all the way through. And you think about the difference, right? So you've got a county that has all the resources, all the experience. They've got, but they're not afraid to say, hey, we want the FBI involved. It's these small towns, which is just the irony, or these are the places that need the help. And for whatever reason, they don't want to use it. It's just really weird, but it results in issues, people. So, wow. Okay, I don't even, which thing were we on here? We were on, what were we on? So many documents. We were on this one. No DNA taken from the garbage out front. This statement is true. Like, I already thought it was true, but even more so now, like, because of the IgG analysis is the origin of this matter. Yeah, it is backwards and forwards. It's all it is. And it's just the problem is if they started with the knife sheath and then connected, like, you see what I mean? If they started with the knife sheath, here's how they could have done this in a better way. If they started with the knife sheath and bypassed anything with the dad and just took the time through IgG to connect it to Bryan, that's different because that's more akin to, like, that's at least closer to what you would have if you run it through CODIS, right? The problem is when you already start because you know who you have a person who you think it is. You see the difference? Like, for example, if they start with, you know, like we've talked about a lot with Casey Anthony, we've learned a lot about how the FBI works, guys. This is really fascinating. Q's and K's. Everything that goes through the FBI lab, forensics, is a Q or a K. Everything. Okay. Q is question, K is known. So when you look at CODIS, that's all Ks. And this actually really makes sense. So what I mean is this. When they tested that DNA on the knife sheath and they got a result and they ran it through CODIS, they had a Q sample. Question, Q sample. If they were able to start with that and through IgG match it to the family based on that, that wouldn't be as much of a problem, but that would have taken a lot of time. Here's what I mean, though. The difference is that they matched it to the dad. And how did they do that? Because they already thought they knew who did it. That's the problem. It's backwards. You see what I mean? Like, if they had just taken the time, like say, for example, like Golden State Killer style, right? You know, like that took a really long time, but they were eventually able to, again, starting with the DNA itself and you know, starting fresh with the DNA, and like, we're not saying this is anybody. We're going to go through this process, you know, and find it that way. That's the right way to do it. But what the problem is when you already think you know who did it, but you don't have any basis for that. And not, or, oh, sorry, you don't have a probable cause for anything at that juncture, right? They didn't have probable cause for anything. They didn't have anything for probable cause. Oh, this is such a mess. So what they used for probable cause was the DNA on the knife sheath, IgGing it to the dad. God, I'm already confusing myself because this is so convoluted. I don't even think they would have done that. How did they? I mean, they must. This is so odd because they must have, because of the way this is worded here. No dark DNA taken from the garbage out front. This is just really a mess, isn't it, guys? Like, here's the thing. My common sense tells you the way they got to the dad, which is the dad garbage as well, right? The way they got to that had nothing to do with the IgG, had nothing to do with the DNA. That's the problem. That's what it is. That's why this is so, okay. That's what it is. The way they got, okay. The way that they, in terms of, for practical purposes, right? The way that they ended up at that house in Pennsylvania, right? Had nothing to do with DNA because they didn't have anything back yet, right? It had to do with the white Elantra and like the bushy eyebrows, right? And thinking it's him. But they didn't have enough at that point for a search warrant or anything else, right? So they just surveilled him. And then we know that when they took that trash, they did not have a search warrant. So they must have still taken that trash before they had any results on the knife sheath. I'm just trying to work through this with common sense, right? Because they're not spelling it out. Because they did not have a search warrant. So they took the trash. And then they must have taken that trash and essentially it's like using IgG, but it's bypassing the process because you're starting with a known sample, right? Well, oh my God. I wish this I'm confusing myself, guys. So, right. So here, I see what you're saying. And you're right in a way. You're right in a way. I know that they don't plan to use it at trial, the IGG. I know that. I know they're going to use the direct match. Here's the thing, though. It all works backwards, right? Because here's the thing. Remember, they're requesting this Franks hearing. And IGG is involved with that, right? And this is more about, okay, the whole thing with Franks, right? It's like saying, did you actually have probable cause? Because regardless of like, the thing is okay, it's the fruit of the poisonous tree, right? Because I understand what you're saying. Like if it's when did the IGG get involved, right? Because even though it's not admissible in court and they're not going to use it in court, it still was used, right, for the search warrants, right, and for probable cause. So it was used to support the search warrants. It was used to support the search warrants, though. So I'm reading your statement again. It was used to support the search warrants. So, and look right here, right? The way the search, what were the search warrants based on? The search warrants were based on Brett Payne's affidavit. Okay, all of them were based on that. All information in the affidavit was gathered because of law enforcement's unconstitutional use of IGG, and thus nothing in the warrant should remain. Now, again, I covered this a little bit ago, but there's a lot of ways it could be unconstitutional. I'm not going to speculate as to that, but there's a lot of ways. And again, I think they just can't be more specific because of the stuff, they're keeping it vague and certain stuff is private, sealed. There's more. For the poisonous tree. Let me see. Let me go back to this other document here. Again, that's the same. There be no investigation into him without the original constitutional violation. It is not that the results of the IGG sped up the investigation. Instead, they focused the investigation on Mr. Kohberger, a person whose only connection to the case was his mode of transportation in the shape of his eyebrows. That's what I was saying. This, as the Idaho Supreme Court has explained, while the initial burden in showing a factual nexus between the illegality and the evidence, the state must show it would have been discovered anyway. That's the crux of the matter right there. That's the crux of the matter right there, that they would have discovered it anyway. Let me read that again, people. As the Idaho Supreme Court has explained, while the initial burden in showing, I think that's what to say is, while the initial burden is showing a factual nexus between the illegality and the evidence, right? So in other words, something illegal happened, evidence looks like you did it. The state must show it would have been discovered anyway. The state cannot make this showing. Without IGG, there is no case, no request for his phone record. So because of the fact that what they're saying is it would not have been discovered anyway, but for IGG. And for me, the trash thing is still at play here. It's a whole other thing. Now I did have, hold on, let me look here. Well, let me pull this back up. There's just like a lot. So am I making sense to anybody? Y'all. So here's the thing about the IG. When that whole thing about the IGG first started coming up, we're talking long ass time ago, right? I remember what people were saying about it, and I was like, they're wrong. People are wrong. Like everyone was like saying, I don't even remember what they were saying, but there was a lot of misconceptions, and I was like, no, they're wrong, they're wrong, they're wrong. So for me, the problems that I'm seeing here are not what people were saying were the problems before, because we didn't have this information back then, right? Because I was one of the people that was able to say, no, they're not going to use the IgG at trial. Like, it's not a problem. Like, I was able to like explain it to people who maybe weren't up to speed or whatever, you know? But what they're referencing here, what the defense is referencing here, these are a whole different host of issues that are not about the process, right? Like, in other words, because there's some people who might try to attack the science. I don't think they're trying to attack the science. Maybe they were initially, right? Maybe they were initially. But that's not what we're seeing here. This is really more about unlawful search and seizure from my interpretation of it. Again, a lot of the IgG stuff is like under seal, but I think that initially they went to attack maybe the science of it, right? Or the fact that it's not been proven in court, whatever, right? And to say, and then of course it was like, well, we're not going to use it in court in the trial. And it was like, okay, great. But then it was like, they took a second look. It's like, well, wait, hang on. But you used it for all the stuff that you used to get to the trial, right? Does that make sense? Hopefully that makes sense. Okay. So I'm going to go, this has been a whirlwind tonight. Okay. Now we're back. We're back to the state's objection. Right. And they were referencing the Washington search warrant, which is how we got off doing the DNA. Okay. Hold on. Let me go back to this instead. This is what we needed to finish first. Hold on. Luckily, everything will be time stamped and it will make it less confusing for those of you guys watching on replay. But we're going as we see things, and that's sort of how it is. So, okay. Right. This is what sent us off on this whole thing. The Idaho State Crime Lab obtained a male DNA profile from the sheath. On December 27th, law enforcement, this is the next part, right? On December 27th, law enforcement agents in Pennsylvania recovered trash that originated from the Kohberger family residence. For anyone who's like, what are you reading? I'm reading the, this is the Washington State application for search warrant. So remember what we were all just talking about, right? This is what they're saying. Let me just scroll to the top so you guys can see the title. This is what they're relying upon to get a search warrant, okay? This is why this matters. Remember how we were saying, like, again, to this comment, I'm not like, I know this is what people have been saying, but the fact that it wasn't used to support any warrant, we're seeing literally it is used to support this warrant and the others, but this is just the one I have pulled up. So this is application for search warrant, people. All right. Now, where was I? Okay. Knife sheath was recovered on November 13th. Okay. On November 27th, law enforcement agents and officers in Pennsylvania recovered the trash that originated from the Kohberger family residence. The trash was sent to the Idaho State Crime Lab for testing. On December 28th, 2022, the Idaho State Crime Lab, or Idaho State Lab, reported that a DNA profile was obtained from the trash. It was compared to the suspect DNA profile. This is it right here. This is it. This is it. This is it. The lab personnel concluded that the source of the trash DNA profile was a male and was not being excluded as the biological father of the source of the suspect profile. This is it. This is the problem. This is the problem. Okay. This is exactly what I was trying to articulate before, because here's this. They started with who they thought was the suspect. So, okay. In other words, instead of using IgG the way you're supposed to, okay. In other words, it's only really IgG because they're not matching it to the actual person. Like what happened was, and think about it this way, right, guys? When they collected that trash, they didn't know whose DNA was on it. So the dad trash was unknown. Remember, think about Q's and K's. This was a Q. Like, we need to think of this. This is really important. This is really important. Okay, this is really important. This matters. Had they collected the trash, and I don't know how this would have been possible, but had they collected the trash and they could have submitted it as a K, it wouldn't have been possible because that can only come from a buccal swab. But just for the sake of the example, as a known to be the dad, that would be completely different. When they collected the trash, they didn't know whose DNA was going to be on it. They didn't know it was dad trash. It would have been a Q. It would have been submitted as a Q to the FBI lab. Okay. or the state crime law. Okay, so it was a Q. Unknown. The only way this is fair and works properly is if you start with unknown and through the process of IGG, you identify it as somebody. What they did instead is they bypassed that and they took a Q. This is it. This is the heart of it. They took a Q, the Q. Okay, the knife sheath, that's a Q. We don't know who it is. Knife sheath is a Q. Trash sample, Q. They took a Q and matched it to another Q to try to get a K. That's what it is. That's what it is. That's what it is. And honestly, I wouldn't have even been able to understand that or hopefully articulate it if I did at all, honestly, without watching the Casey Anthony trial, because that's where we really learned how the Qs and Ks work. But that makes sense. So they took a Q and matched it to another Q. And that's why you get this answer, right? It's about could you exclude people? And again, the biological father source of the suspect profile, but that's a Q. Oof. Again, here's how it would have been more fair. Just to reiterate, had they taken the trash sample, Q, and through IGG ended up finding somebody down the way that, and then finding it that way, that would have been legitimate, right? Or conversely, had they not had any trash sample, had they just had the knife sheath, like a cold case, right? Say, for example, where they have it, but then they, through IGG, can identify a suspect that way. That's also legitimate. Instead, they had the knife sheath, Q. They had the trash, Q. And they compared them to each other. And why does that matter? Because that shows that you already think you know who did it, but you don't have any probable cause. Like the fact that you're using Kohberger's dad is because you think it's Kohberger. And the other thing I was going to say is that, what was it? Oh, I lost my train of thought. I interrupted myself with my own brain. Yeah. Anyway, so hopefully that makes some sort of sense. Oh, I know what it was. It was this. I was going to go to the thing. Well, it's on a different document, but we just read it. The thing where it's like they would have had to have discovered it on their own. That's the point, right? Where it says that law enforcement would have had to have come to the conclusion on their own. That's why when you look at these cold cases or like Golden State Killer, that's why, for example, again, if they had just taken the DNA from the knife sheath and used IGG and had nothing else to go on and round up at Bryan Kohberger or his dad for that matter, that's legitimate. That would stand up. That would hold water because it's saying that they would have gotten there on their own without any additional stuff. Same thing if you went with only the dad trash, where they had this piece of trash. It's a Q, right? Don't know who it is. They have the DNA, but they don't know who it is. Through IGG, they're able to connect it to Bryan Kohberger, right? Or to the dad, whatever. Also legitimate. But they are taking two Qs and matching them. So that's the problem, I think. That's I think the best way to articulate this. And all that to say, it's really the same thing I was saying before, where it's kind of circular, right? You're taking a question, try to get the answer to a question, which is a question, and it's all questions. And it only works if you think you already know who did it, but you don't have any proof. You see the problem there, guys? This information is being provided to the court pursuant to my duty, blah, blah. So, but this right here, though, guys, right? So let's just dispel any misinformation, or I'm not saying anyone's doing it intentionally, right? This is complicated and confusing and convoluted, as I've said. Let's just make sure this is clear. This is an application for a search warrant, and it is relying on the DNA. And the reason it's IGG, right, is because it's familial. That's where you get to IGG. It's not a direct match. If it was a direct match, it'd be different, but that's CODIS, right? That's CODIS. That's why CODIS will, like, you can't deny that. If they have the DNA from the thing and it's a Q, but then it matches the K in CODIS, right? You're good to go. That's a direct match. So right here, because of the fact that they did the trash and then they were like, oh, it can't be excluded as the fault. Like that's IG. It's not IGG the correct way as it should work legally, right? But it's like using it kind of to try to fit who you think did it, but it still is in that realm because it's not a direct match. It's the father of the source. The father of the source is still where you get to maybe improperly applied IGG, as it were. Yeah, but here it is. This is in the search warrant application. There you go. So they relied on it. And again, this is going to be the basis for a lot of those motions they have. So here's the statement of Dustin Blaker. Oh, wow. Okay. So on November 13th, Moscow PD, Brett Payne and I responded to, so this is the other guy that responded to the house to assist with the security and processing of a crime scene. Sergeant. Okay. So he's also from Moscow PD. Okay. Okay. MPD Officer Smith, one of the initial responding officers to the incident, advised he would walk me through the scene. Officer Smith and I entered the King Road residence through the bottom floor on the north side of the building, walked upstairs up to the second floor. Smith directed him down the hallway to the west bedroom on the second floor, which I later learned was Xana's room. Just before their room, there was a bathroom door on the south wall of the hallway. As I approached the room, I could see a body, later identified as Kernodle's, laying on the floor. She was deceased with wounds that appeared to have been caused by an edged weapon. Also in the room, hang on. Just before this room, there was a bathroom door on the south wall of the hallway. Wait. Officer Smith directed him down the hallway. So he already knows where the bodies are. This is something, what? Okay, whatever. Officer Smith directed him down the hallway to the west bedroom on the second floor. What's the part about the bathroom door? Just before this room, there was a bathroom door on the south wall. See, that's why I was confused, because I was like, wait, as you approach which room, the bathroom or the bedroom? Because why are you, anyway. I guess he means the bedroom. I could see a body, later identified as Kernodle's. Also in the room, I guess bedroom, right? That's, anyway, this was confusing in a weird way to put that, and I don't know why it's there. Ethan, so then he followed Smith upstairs to the third floor. Third floor consisted of 2 bedrooms and 1 bathroom. The bedroom on the west side of the floor was later determined to be Kaylee Gonsalves, hereafter Gonsalves' room. I later learned there was a dog in the room. Well, that answers the, okay, I was talking about that earlier, when they responded. Well, we don't know. Okay. We know they shared a wall. As I entered this bedroom, I could see 2 females in the single bed in the room, right, in Maddie's room. Both Gonsalves and Mogan were deceased. They located the knife sheath laying next to Mogan's right side. This DNA on the snap. They interviewed the survivors. That's weird that's a different color. Learned the following. They're at the bar. We know all this stuff. DM and BF both made statements during interviews that indicated the occupants of the King were arrested from home by 2 a.m. and at least asleep or in their rooms by 4 a.m. This is with the exception of Kernodle, who received the DoorDash. DM said she originally went to sleep. Okay. She was awoken at 4 a.m., but what she said sounded like Gonsalves was playing with her dog in one of the upstairs bedrooms. So that's why I was confused, right? Because again, we don't know when the dog, so the dog was found in Kaylee's bedroom, which is weird. Seems like well, again, it's weird, right? Because she, like, you would think the dog would be with her. I don't know. She was going to be in Maddie's room, but the dog was found in Kaylee's room. So we just don't know. Is that where she put the dog, or was the dog moved there later? By what she stated, sounded like Gonsalves was playing with her dog in one of the upstairs bedrooms. So she doesn't know which bedroom, apparently, I guess. That's why it makes it confusing. Not that she should have known, but, you know. She thought she heard Gonsalves say something, there's someone here. It could have also have been Kernodle because she was awake and using TikTok. Did I say TikTok? Oh my God, TikTok. She didn't see anything. She thought she heard crying. She heard someone say, "I'm going to help you." The dog can be heard barking. DM opened the door, and for the third time saw a figure clad in black. Yep. Bushy eyebrows. First, we know all this stuff, but yeah. There's a suspect vehicle. And so this is, again, this is the first thing, right? It's the suspect vehicle. Like, that's the first thing that they had, because there was really no way around that. Well, I mean, yeah, I don't think anyone's disputing that, because you know what's wild, though, is I guess it doesn't show somebody getting out of the car, you know? I mean, amazing that there's not a camera that pointed to where the vehicle actually parked, right? Like, has anyone ever thought about that? Maybe it's been a long time. Like, did somebody do some sort of like sleuthing to make sure that like where the cameras were? Like, I don't know. Like if they, because it is odd, right? Because there's cameras. I mean, these days, a lot of people, especially, well, it depends on the area, right? But a lot of people have Ring cameras. I think that if you're going to commit a crime, don't do it. But, you know, in other words, I would imagine that if you're trying to commit a crime and get away with it, right? It's like, you probably should be under the impression that there's cameras everywhere. You should probably assume you're going to be on camera. Just assume it, right? But then if you're trying to figure out if, in fact, there is a place where there isn't a camera, you'd want to know where those places are. Anyway, it's just interesting, right? Because it's like, what are the odds, right? That like parking there, anybody, right? Even if it was like the roommates coming home, right? Like anyone could be, like, in other words, it doesn't seem like there was a camera that would show people coming and going from the house, walking in the door, parking, that type of thing. That's my point. So yeah. Yeah. Okay. So they found latent shoe print, cellular material, diamond shaped pattern outside of DM's bedroom. Video canvas. Aha, back to the video. Here we go, right? Video canvas was to obtain any footage. Right. Okay. So this video canvas resulted in the collection of numerous surveillance videos. Reviewed them. A review of camera footage indicated that a white sedan here after suspect vehicle 1. You know all this, but I mean, again, the sightings show it make 3 passes by the house. It's just so wild that it doesn't show up parking and somebody getting out of the car, right? Very few cars enter and exit. I mean, I believe that. There it is. So I think that turning around was because of the DoorDash. So they, I mean, all this, but again, it's just so crazy, right? What are the odds? It doesn't have it like at the house. And then they've got the car dude. And I don't know, there's really, yeah, all this. Anybody else see a problem with this, right? Remember what this is? This is you applying for a search warrant, probable cause for search warrant. And this is the map that you're providing to the magistrate judge. For anyone who missed it, there was a hearing actually where Brett Payne was on this, it was an evidentiary hearing for some, I don't even remember what it was for. I think maybe, I don't remember what it was for. Anyway, this is a couple months ago. And Ann Taylor provides him, it was either this map or what, there's a number that are similar, that are just as bad, right? Shows him the map because it was something that he put in his affidavit. And she's like, oh, can you tell me on the map? And he's like, I think he'd forgotten about the map because he looks, he's like, I can't read a thing that's on there. And then she's like, yeah, like she didn't say this, but it's like, that's exactly my point. This is completely useless. Like, is this deliberate though? Honestly, like, is this, I mean, when it comes to that Frank standard, right? Because how can you possibly make a map that bad? How? Like, even if you tried, how? Like, this is bizarre. Anyway, you guys see what I'm saying? Like, these maps alone are problematic to me. You're relying upon this for a search warrant. It's not that hard to do a better map, right? It's just not that hard. Like, it should. Anyway, okay. So, and then all the subsequent. So now let's go back to where we were with the state. So, Okay. Oh, all right. Let me drink some water. As demonstrated by the Washington search warrant and amendment, the search of the defendant's residence was done pursuant to specific Washington court-issued search warrants based on substantial probable cause. Well, you know what? Now I'm glad we went through all of that, right? Because we went through the Washington search warrant. That was what we were just reading. We went through their probable cause. We went through the bit about the IDG, and we also went through the significance of it as it pertains to a Frank's hearing. So this all, now we have a lot more context for this, I feel like. Okay. As to the balance of the defendant's submissions, the state respectfully refers the court to and incorporates herein the state's separate responses to the defendant's Frank motion. Conclusion, deny the things. Okay, next. So this is Apple. Let me find something real quick. Okay. So yeah, okay. Apple. Wait, what? What happened? These get out of order. Okay. Okay, Apple. So so this is in the same one. This is in all these, I think, where they're saying it's, oh, wait, no, that's something different. Right. This is interesting. So when I was covering these motions to suppress, I noticed this part about the contemporaneously filed motion. And I actually said, I don't remember contemporaneously filed motion. I looked at the docket and I was like, there's nothing contemporaneously filed. And I actually said to myself, interesting. I wonder if that was, because remember when they asked for an extension on filing discovery motions, and it was on the eve of the deadline, and it was denied. I said to myself, or I said to you guys, I was like, guys, remember how there was supposed to be another contemporaneous motion and I hadn't seen it? My guess is that's what they were asking for the extension for on the eve of the deadline. And I said to myself, I wonder if that means that they're not going to be able to file this. And sure enough, he didn't give them more time. So the reason that they are saying, well, we don't have this contemporaneously filed motion, I think that's why. I think they missed the deadline and it didn't get filed. And I guess that will be whatever that is. We'll never know. But that's pretty crazy. Okay. Here we go with facts. Regarding the defense represented facts in scare quotes, the state respectfully refers the court to the defense exhibits A through D. It says the exhibits are attached as follows. They're all under seal, but they will be attached someday, basically. Arguments. Apple account information falls within the third-party doctrine. This reminds me a lot of what was going on with Shannon Gardner with the Google. This is a problem, and the law is going to have to deal with this because third-party doctrine, right? You have no reasonable expectation of privacy. That's the problem with things like this, whether it's Amazon or Google or Apple, because they have all of your information. And it's like, I don't know, man. I don't know. This is something the courts are going to have to deal with. But that's really not for a trial court. That's going to be something for a higher court. And I think I'm trying to remember what the defense said about this. Let me see. I'll see what they said about it, just to remember. Okay. That's what they were seeking. I'm looking for the third-party doctrine. Aha. This case is not about bank records, but about data collected by a third party. Okay. Apple. There we go. So which back up or duplicate his internet-connected devices. From the standpoint of the Fourth Amendment, the data Apple collects can provide a massive amount of information about a person's private life. Yeah. In his affidavit supporting the issuance of the search warrant, Kohberger acknowledged that Apple products often require the creation of an Apple account to use their products. So right there, the reason they're saying that is because that's saying that you should have an expectation of privacy because you have to create an account. Corporal Payne noted that Apple accounts provide access, blah, blah. They do all the things. Okay. Face ID. That's another good point. Here's all the stuff that they can get. As for Idaho, there can be no doubt that Article 1, Section 17 requires a warrant for law enforcement who can access Idahoans' online records. Apple is heavily regulated and guarantees its customers' privacy. Footnote 6. Apple is subject to the provisions of the Federal Electronic Communications Privacy Act. To the extent that this court might see this as a third-party doctrine issue, the arguments made in Mr. Kohberger's memorandum in support of expressing Amazon records fully argue that doctrine and are incorporated here. Now, the memorandum, I believe, is one of the things that's under. Oh, the memorandum, I think, is they're referencing. It's the one memorandum that they used for the Franks hearing. So that's under seal. Yeah. Okay. So now back to this where we were. So, right, third-party doctrine. So, first, the defendant voluntarily discloses subpoenaed information to Apple. You guys, I don't know. It is just an issue that's going to have to be litigated and figured out, right? Second, as the defendant knows from the review of the discovery, the information obtained from Apple was in no way detailed and comprehensive record of the defendant's movements. The state was justified in relying on the information provided from the U.S. Attorney's Office, which simply confirmed that the defendant had Apple iCloud accounts. This is allowed. The state says. This is allowed. As to the subsequent search warrant, the state established probable cause for the remainder of the items sought, as shown by the lengthy and detailed affidavit. Defendant has not demonstrated that the search warrant affidavits contain intentionally or recklessly false statements or omissions. So again, that's that Frank standard, right? And again, it's all incorporated with the Franks motion for Frank's hearing. The Apple warrants incorporated the affidavit for probable cause and Exhibit A by reference. The defendant next asserts that the search warrants fail to command law enforcement. Oh, right. I remember that part. That's sort of like an overbroad thing. That's what this is basically saying, that they didn't specifically say, go and get this specific thing. I'm not going to read all this because, I don't think that's going to go anywhere. The Apple search warrant was not a general warrant. Again, this is about being overbroad. I guess they're kind of related but different. Like the first one, right? The not commanding them to search. What that basically means is it didn't actually say go get the thing. But then this one being a general warrant that as alleged by the defense is the overbroad. So they're related but different. So the Apple search warrant, when considered with the search warrant affidavit and Exhibit A, satisfies the particularity requirement. So they're saying it's specific enough. When the Apple search warrant is considered along with the affidavit for probable cause and the 25-page Exhibit A, the warrants are sufficiently particular and valid. While the Apple search warrant was broadly worded regarding each category of digital evidence listed, the search warrant affidavit and Exhibit A provide the particularity necessary to satisfy the three-factor test set forth in Teal. First, probable cause existed to seize all items of a particular type described in the warrant. The Apple search warrant sought evidence of defendant's plans, thought process, research, blah, blah, located on Apple accounts. The defendant, here we go, was seeking an advanced degree in criminology and had studied cloud-based forensics prior to the crimes. Defendant had attempted to conceal his location during the time of the crimes. I was like, wait, how do they know that for sure? Y'all. I was like, wait, they figured that out? How did they figure that out? Sadness. So this means it's referencing the previous citation. Now, the previous citations all say that. What are they referencing? They're referencing Exhibit A. That's Brett Payne's affidavit. So I know, so now that's when I was like, oh God, I know exactly what they're talking about. This is so silly. I've made fun of it before whenever I've gone over the affidavit. So they're saying this part here, I'm like, oh wow, they figured that out. How did they know he attempted to conceal his location? Yeah, they didn't. They didn't. This is like that game of telephone in kindergarten. So what they're referencing is the affidavit. What Brett Payne said in the affidavit was something akin to the phone. We don't know where the phone was during these hours. And it's like, and in my experience, people committing crimes will turn their phone off in order to conceal their location. I'm probably making it sound better than it was because basically it's complete speculation. And I pointed it out at the time. I was like, oh my God, like this is so dumb. And like, anyway, they're saying that so it went from speculation of Brett Payne saying, in my experience, sometimes criminals will like turn their phone off or put it on airplane mode. Okay. It went from that to this. Defendant had attempted to conceal his location. Incredible. Incredible. Glad I caught that. Together, the above established probable cause to search for evidence of defendant's plans, thought, blah, 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 blah. I'm going batty. I've read a lot of documents tonight, guys. I was reading them even before I went live. Second, the warrant set out objective standards by which executing officers could differentiate items. Investigation to burglary and or homicides. Third, the government was not able to describe the items more particularly, considering the information available to it at the time the warrant was issued. They couldn't narrow it any further. So that's part of the argument the defense was saying was like they could have narrowed it further and they chose not to. And that's really one of the standards when it comes to the narrowing of the search warrant, that you have to make it as narrow as you are able. And they're saying they were able, like the defense is saying they're able. The state is saying they were not able. What a shocker. No. Unlike general exploratory warrants, the Apple search warrant allowed the searcher to reasonably ascertain and identify things which are authorized to be seized. I would still say that even the examples they gave are pretty broad. Like this, for example, evidence of defendant's plans, thought process, research, locations, photos, or other pertinent information. You see how subjective that is? And literally you could look at anything and be like, oh, it's pertinent, right? You see what I mean? So like, while I think that they're probably going to win because that's what usually happens, you know, I think if anyone were to actually take a look at this, they'd be like, wait a second. The state is giving their examples of how it's not overbroad. And like, if you actually scrutinize it and look at the examples, it's like, what? Like a specific example. Anyway, it's just, yeah. Okay. Next one. Make sure I'm on the right one. Okay. So now we are on the arrest warrant. Yeah, there's that same footnote. Again, I think that's because of that discovery thing. You know, I don't think anyone else caught that, but I was really curious because when the defense did reference the contempt, like this is a big deal, right? Like the motion that was going to be filed that didn't get filed, right? Motion for an order suppressing all evidence gathered by law enforcement as a result of his arrest. It sounds like it's obviously important, right? And I was like, it seems like a big deal when they referenced it initially. It was like they were almost kind of relying on that. So that's why I was like really shocked when I was like, well, fuck, like I guess they didn't get in at the deadline and they're not allowed. That seems like a huge deal. And I wonder, like, I just wonder kind of like what will happen because, you know, ineffective assistance of counsel. I don't know. I feel like that's why usually you'd be given a chance. Like, it's for that reason. It's for this reason, right? That you could see why judges would say, okay, fine, I'll give you another blah. And I totally get it that they like filed it on the eve. And he might have said in that, he might have even said, you know, unless you can show good cause. And it's possible that they had an in-camera hearing. I know they did have an in-camera hearing, but we don't know what it was about. And that they made that they explained it to him and he said, okay, fine. Because otherwise what you're looking at is potential issues, right? For appellate, like issues where it could get, you know, ineffective assistance of counsel. Because what I'm thinking is if they couldn't get it filed by the deadline, and I'm not blaming them because they have a lot to do, right? But still, a deadline's a deadline. If they didn't ask for an extension in a timely manner, first of all, and if they couldn't get the thing filed in time, and then that thing is kept out and that thing is important, you see what I mean? I can see that being problematic. So anyway, these motions all address search warrants issued and served in the state of Pennsylvania. The state is unaware of any Pennsylvania arrest that would be arrest warrant that would be subject to the same analysis. Adding to this confusion is the fact that the titles/captions the defendant uses in the text of his instant motion all refer to search warrant as opposed to arrest warrants. The only mention of an arrest warrant is in the defendant's conclusion on page 7. Well, it's because they're saying it's all related. It's all through the poisonous tree. That's what I think there. Anyway, to the extent that the defendant is referring to his arrest in Pennsylvania and to avoid unnecessary repetition, the state incorporates, again, both the defense and the state are doing something similar here. What the defense is doing is for a lot of their motions, they're relying on their memorandum in support for Frank's hearing, which is of course filed under seal. So like reference that, right? The state is doing the same thing in the sense that they keep referencing, rely on the state, this one, and this is also under seal. Which itself incorporates the state's responses to the Frank's motion. That's probably why it's related to that. Regarding the defendant's represented facts in scare quotes, the state respectfully refers the quote to, you know what's interesting is we're not getting a whole lot of information out of these. Applicable law. Again, they just keep referencing the same things and we can't see them. Valid search warrants. Beginning at page 4 of the instant motion, the defendant asserts that the affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material information. Substantively, this section of the defendant's motion merely refers to the defendant's separate Frank's motion argument. By way of preliminary response, the state notes that Idaho law clearly states that if a search is conducted pursuant to a warrant, the burden of they've already settled this. Oh my God. I feel like they're saying words and they're not saying anything. Does anyone else get that impression? Like, this is like not, I don't know. Is it just that they're being like really dismissive of it? That's a possibility. Because again, while the defense was relying a lot on stuff that they couldn't talk about because it was under seal, they still had a lot more going on in what they were discussing. And this seems just kind of like repeating themselves over and over. And I know the defense also did repeat themselves a lot. There was a lot that was the same, but there was also things that were different. And there was, I don't know. I don't know. Seems lacking. Okay. What is this one? Is this a different? Hold on. Oh no, we're on ATT. Okay. Okay. So ATT first warrant. Now, they didn't do this in any of their other motions. Wait. Oh, this is the motion to suppress, not the objection. Okay, wait, hold on. I clicked on the wrong thing. Sorry, guys. I was like, wait a second. Okay. Um, okay. Here we go. This is where we're at. I was like, wow, look, I was actually going to say, wow, look at the state. They like actually did some other stuff that's different. Oh, wait, no, that was the defense's original motion. All right, state's objection to defendant's motion to suppress cell phone USB file. Okay. Arguments. Defendant has not demonstrated search warrant affidavits contain intentionally or recklessly false statements or omissions. The next, okay, interesting here. All right, the defendant next addresses its Frank's argument. The state incorporates its argument and pleadings on the Frank's issue at this point, as opposed to restating the same. Well, that's good. IGG. The defendant raises its objections to the IGG, and again, the state incorporates the state's arguments in response to the defendant's separate IGG motion, as opposed to restating the mirror. And that's under seal. God damn it. The search warrant incorporated the affidavit for the search warrant and Exhibit A by reference. The defendant next asserts that search warrant fails to command law enforcement to search the USB drive. The state incorporates the state's objection. So the thing we just read, remember the one we just read, and I was like, okay, there's like the overbroad, but then there's also like the lack of not commanding them to search. They're saying just take our same argument and stick it in here because it's the same type of thing, which is not untrue. The cell phone warrant was not a general warrant. Again, incorporating, but that's really funny. They're like, let's just copy and paste. Wow. While the Seagate 2 terabyte external USB hard drive search was broadly worded regarding each category of digital evidence listed, the search warrant affidavit and appended exhibit provide the particularity necessary to satisfy the three-factor test set forth in detail. First, probable cause existed to seize all items of a particular type described in the warrant. Specific USB drive with identifying serial number was listed. The scope was expressly limited to November 13th. Second, the warrant set out objective standards by which executing officers could differentiate items subject to seizure from those that were not. The seizure of items was limited to the crime for which the defendant was arrested. Okay. Following types of evidence: communications, written text communications, contact, location information, internet history, bookmarks, written and audio notes, and indicia. I don't even know what that means, to be honest with you guys. Maybe it's just because my brain is, this is, maybe, yeah, no, I don't know. So it says signs, indication. Oh, right, of course, right. No, it's like, I did know that. I forgot. Yeah, indications. That makes sense. That makes, but what does that mean as it pertains to a search warrant? It's like the literal description of vague is this word. Okay, third, the government was not able to describe the items more particularly. Okay, this is that whole thing again about being able to, as narrow as possible, as is able. In summary, given the circumstances of this case, they're saying it was good enough. Okay, all right, up next. Elantra. Okay. Let me just pull up some real quick here. Okay. So, okay, this is the Elantra. So, what are they going to say? Probably a lot of it the same footnote on each one of these there. That contemporaneous motion that we'll maybe never see. Okay, you know what? I think what I'm gonna do, let me see how many more of these we have. So Yeah, I think I'm going to stop here for tonight, and then we'll have to split this into 2 parts. You never know how long these things are going to take, but we had a lot of other things that we kind of brought up that all of it will be timestamped. So what I will do is we'll pick up here next time. But here's the other thing. I have some other things I do want to loop back on, which have to do with the case law, Pennsylvania case law about trash. And I think I also had something else pertaining to IDG. I'll have to take a look. Honestly, guys, I almost feel like it would be worth it. I don't know if it would even be possible to find it because there's so many hearings, but to go back to the initial discussions around the IDG in terms of the filings and the hearings, the things that weren't under seal, and to go back and re-watch it. I'll think about that. Let me know if it's something, if you guys are watching, if you guys want to let me know in the comments, let me know if that's something you'd be interested in, because that was such a long time ago, right? That was like one of the first things that happened in this case. It was from such a long time ago that it might be worth watching. And because I've been toying around with that idea anyway. Let me know if you're interested in going back and delving through some of the earlier stuff with the IDG. And now that we have a lot more information, and now that there's different context for it, just let me know if that's something you guys are interested in. But yeah, I'm gonna go ahead and end it here for tonight, I think. And then we will cover the rest of these next time. So as always, thanks for watching, and I will see you guys next time. And squirrel out.